Chair Weeks, it does look like everyone that we are expecting tonight is here. I'm not sure if Commissioner Carter is able to hear us though.
Hello.
We can hear you. Thanks, Charles.
Okay.
Clear. Thank you.
Okay, we'll start in about 2 minutes.
All right, Chair Weeks, staff is ready when you are.
Okay, thank you. All right, I am going to call the March 25th meeting of the Planning Commission to order. And I'll read the following statement. Due to the provisions of the Governor's Executive Orders N-25-20 and N-29-20, which suspends certain requirements of the Brown Act and the orders of the health officer of the County of Sonoma to shelter in place to minimize the spread of COVID-19, the Planning Commissioners will conduct today's meeting in a virtual setting using Zoom webinar. Commissioners and staff are participating from remote locations and or practicing appropriate social distancing. Members of the public may view and listen into the meeting as noted on the city's website and as also is noted on the agenda. Members of the public wishing to speak during item 4, the public comment portion of the meeting, or during our public items, will be able to do so by raising their hand and will be given the ability to address the commission. And now, Mr. Host, if you will call the roll, please.
Yes, let the record reflect that all commissioners are present, except Commissioner Kalia.
Thank you. We have approval of the minutes. They were attached from February 25th. Are there any amendments to the minutes? Okay, so then they will be approved. Now we're going to the public comment portion of the meeting. And we're going to open the public comment for any item that is not included on this meeting's agenda. If you wish to make a comment via Zoom, please select the raise hand button. If you are dialing in via telephone, please dial *9 to raise your hand. Each speaker will have 3 minutes. A countdown timer will appear for the convenience of the speaker and viewers. Please make sure to unmute yourself when you're invited to do so, and your microphone will be automatically muted at the end of that countdown. Mr. Host, do we have any public comments?
Yes, we have a few raised hands. I do want to reiterate that if you wanted to speak on an item on the agenda, there'll be a time for that when the agenda item's called.
Yes, so this is for items that is not on the agenda tonight.
All right, got a couple of hands went down. We got one with Kelly. Oh, nope, all hands have been lowered.
Okay, thank you. So wait just 1 second, a couple seconds more, see if there's anybody else. Doesn't look like there is, so then that will close the public comment portion. I would like to make a statement of our purpose as a planning commission, this is something new we're going to be doing at each meeting. So the purpose of the planning commission is as follows. The planning commission is charged with carrying out the California planning and zoning laws in the city of Santa Rosa. Duties include implementing of plans, ordinances, and policies relating to land use matters, assisting in writing and implementing the general plan and area plans, holding public hearings and acting on proposed changes to the zoning code, zoning map, general plan, tentative subdivision maps, and undertaking special planning studies as needed. So this is the time now for any planning commissioners, if they have any comments they'd like to make. Any comments? Okay, well, I do. So just a reminder that your Form 700s are due. And we also received an email regarding harassment training. So hopefully you've signed up for that. If I know some of you probably are participating in that in your other work lives. Earlier this month, I attended the mayor's lunch with board and commission chairs, and Mayor Rogers talked about the goals that were established during the 2021 goal setting in February, and they're pretty much the same as those that were set in, it was August 2020 when they did their goal setting. And they are things such as COVID recovery, public safety reform, housing and homeless, and the economic and budget stability of the city. So that's it for me on that. And so now we'll go to department reports. And Mr. Rose, I think you have that item.
Yes, thank you, Chair Weeks, Vice Chair Peterson, members of the commission. It's nice to see you all. Just two brief announcements. Tonight, Andrew Triple will be presenting the project, the Brush Creek Road Appeal Project. So due to that, I'll be the liaison throughout tonight's meeting. And then also Ashley Crocker is out tonight. So we're privileged to have Sue Gallagher with us. So she'll be the city attorney on tonight's meeting. And that's all I have.
Thank you, Mr. Rose. Are there any abstentions by the commissioners? Okay, so seeing no abstentions, we don't have a study session and we don't have consent items. So we will go on to item 9.1. As Mr. Rose said, Mr. Triple will be presenting this item. This is a public hearing, 1900 Brush Creek Appeal. And I'd also like to ask the planning commissioners for any ex parte disclosures on this item. So we'll start with Commissioner Carter.
I did visit the site and I have nothing further to disclose.
Thank you. Commissioner Duggan.
I visited the site and I'm also acquainted with Rose Zoya, who's the lawyer for the builder, as she is a part-time spin instructor at the YMCA, and I am a sometime member of her class, but I've had no contact with her outside of class.
Thank you. Commissioner Holton.
I have visited the site and I have nothing to disclose.
Thank you. Commissioner Krupke.
I have nothing to disclose.
Vice Chair Peterson.
I visited the site and have nothing further to disclose.
And I also visited the site and spoke briefly to consultant for the property owner before the last planning commission meeting, and nothing further to disclose. So Mr. Rose, if you would like, I'm sorry, Mr. Triple, if you would like to go ahead and start your presentation.
Hey, good afternoon, planning commissioners. If you would host, please let me know if my presentation is sharing.
We can see it.
Great, thank you. So this evening's report item is the 1900 Brush Creek Appeal. It is a continued item from February 25th, 2021. And the project location is 1900 Brush Creek Road. It's located in a low-density residential area of Brush Creek Road. So the issue description, as we can see in this site plan, there was an existing house with accessory structures, and an addition was made, a 12 by 30 addition was made to the existing house, and a redwood tree was removed in order to construct that addition. Those actions were taken without benefit of a building permit or authorization for tree removal. So a summary of the action appealed. The determination was made by code enforcement and building divisions that a building permit would be required in order to legalize construction of the addition as well as tree removal, and that building permit would require planning review. During review of the building permit, which we can see here is still currently in progress, the planning director determined that the proposed project complies with subject parcels, final map, and required building setbacks, and approved the tree removal subject to mitigation as required by the city's tree ordinance. I would like to note here also that when the building permit is issued, the building permit fee would be doubled because this is a building permit to legalize unpermitted construction. So the regulatory framework under which this building permit was reviewed by Planning Division includes Title 17 Environmental Protections of the City Code, specifically Chapter 17-24 Trees, which we refer to as our tree ordinance. And within that permit category 2, tree alteration, removal, or relocation on property proposed for development. Additionally, we included a review under Title 20, which is our zoning code, specifically 20-22.050, residential general development standards, and 20-28.050, the scenic road combining district, as well as the applicable final map, which is parcel map number 609, dated May 30, 2001. So some key dates during this project's evolution in 2020, and what brought us to this public hearings or a review by Planning Commission in February and then today in March. In early 2020, a code enforcement case was opened in response to a complaint. In March then, COVID happened, and that led to a shelter-in-place order, and all city staff were directed to not come into the office. We spent several months moving into a work-from-home mode, but that did delay code enforcement action upon the complaint. Code enforcement was able to respond to that complaint and to other complaints commencing in August of 2020, and then in September of 2020, they issued a notice of violation for the unpermitted tree removal, as well as informed the property owner that a building permit would be required for legalization of the unpermitted construction. During the ensuing 2 months, the property owner did submit a building permit application that was rejected due to incomplete or insufficient information. That was then resubmitted in December. On December 11th, building permit B20-6871 was opened. Planning staff provided a preliminary review of the building permit and made determinations, but did not final planning review of that building permit. To my knowledge, the complainant was informed of those planning director determinations. And on December 14, 2020, an appeal application was submitted, followed by an amended appeal application on December 16, 2020. So the grounds for the appeal on the appeal application dated December 14. First was a lack of enforcement of final map building setbacks, whereby a property setback is being voided to enable an illegal build. And then that it allowed the planning director allowed removal of redwood heritage tree to enable an illegal build. Then the appeal application was amended and resubmitted as an amended appeal application dated December 16th, in which the grounds of appeal were reduced to one item being a zoning code violation, a home addition that was not within the building envelope, and removal of a heritage tree. I would note at this time that the appeal application and grounds for appeal were the only items submitted. There were no accompanying information with those application submittals. So during the review of the building permit with regard to ground for appeal number 1, in that the building setbacks on the final map were not enforced, planning director, planning staff reviewed the project for zoning code compliance. Through review of the zoning code applicable setbacks, we determined that the front setback is established here across the lot frontage and in relationship to Brush Creek Road. The rear setback is established here with a 20-foot building setback. Then an interior side setback is established here. And then on this side of the project site, there is also an interior side setback of 10 feet that's established, except that there is a public access easement, or public utility easement and access easement, seen here as private road utility easement. And the zoning code would require that there is no development within an easement. So therefore, planning staff reviewed the addition to determine that the extent of the addition was located outside of the easement shown on the final map. So here we can see the parcel map number 609, which is one of the regulatory documents to which the project review is subject. Lot 3 is the subject parcel with lots 2 and lots 1. This property was subdivided in 2000 timeframe and then subsequently developed over the 2 to 3 years following. Here is clearly shown the private road utility easement, public utility easement, public sewer easement, which also serves as a emergency vehicle access easement to allow access for fire trucks and such to lot 1 and lot 2 with a hammerhead turnaround located here. The parcel map also includes a supplemental information affecting sheet, and I wanted to show the sheet in its entirety at this point, and then zoom into one of the particular items of note. This, what we call the supplemental sheet or the local agency information sheet, describes building setbacks. And through application of state and local ordinance, as well as information provided on the supplemental information sheet, it was determined that these setbacks are not enforced and are not, or rather are not enforceable. For this reason, then planning staff turned to the setbacks required in the zoning code. So then we move on to the tree removal analysis. The tree that was located here adjacent to the existing house prior to the addition. And that tree does meet the definition of a heritage tree in that it was a redwood tree of sufficient circumference or diameter at breast height to be defined as a redwood tree. Therefore, the tree ordinance would regulate removal of the tree as well as mitigation requirement. During the review of the building permit, planning staff determined that in fact the tree was removed, that it was removed as a removal as part of development. So it was a permit category 2 tree removal. The tree ordinance does allow removal of trees for the purposes of development, provided that the tree removal is authorized and mitigated. From planning division's perspective, we view the removal of the tree as being part of the construction of the addition. Therefore, if the requirement is that a building permit be obtained to legalize construction of the addition, then that tree removal is incorporated into that building permit and evaluated as part of the project submitted for review. Planning director determination was to authorize removal of the tree and to require mitigation of the tree at a standard of replanting with 2 trees of at least 15 gallons in size for 6 inches or an increment thereof of the diameter of the tree removed, or to make a payment of $100 per required tree for replanting to the city's tree fund, or a combination thereof. Planning staff worked with the property owner to arrive at a tree mitigation requirement, and that was presented to as part of the project as attachment 5 tree mitigation request. In terms of environmental review analysis, planning staff determined that the city's issuance of a building permit involves only the use of fixed standards or objective measures, and is therefore a ministerial action that is not subject to environmental review under the California Environmental Quality Act. Therefore, planning's recommendation is that Planning Commission by resolution deny appeal of the planning director determinations made during planning review of building permit D20-6871, thus affirming the planning director determinations and allowing processing of the building permit application to resume. And I'm available to answer any questions. Thank you.
There. Thank you, Mr. Triple. Do you have any, does the commission have any questions of staff at this point before we hear from the property owner and the appellant? A couple things I would just like to clarify is that we're really looking at this in three different ways, or three different things. One is that the zoning code compliance, and was that correctly applied? Was review of the tree removal as part of the building permit correctly applied? And was mitigation for that tree removal correctly applied?
Yes, Chair Weeks, that is correct.
Thank you. So now if we could go to the applicant, the property owner's presentation, and you'll have 10 minutes, and please adhere to those time tables. So I'm not sure who is going to be speaking for the property owner.
Good evening. It's not evening yet. Good afternoon. Can everyone hear me? This is Rose Zoya. I will be speaking for 6 or 7 minutes or so, and then Tony Cabrera has about 3 minutes.
Okay.
Thank you. I represent the homeowners, Amber and Daniel Lee Howe. Thank you so much for the opportunity to address the commission on this matter. First, we would like to thank all the staff who have been involved for the inordinate amount of time they have spent on this relatively minor project. One quick housekeeping issue. I just exchanged emails with Andrew regarding civil engineer Mike Robertson's October 2020 letter, which was redacted, the content of it redacted in the staff package. I just noticed this about an hour ago while I was reviewing the updated staff report. I spoke with Mr. Robertson, who is in some remote place in Arizona where he cannot access an affidavit I sent him allowing release. So he did leave a message for Ms. Gallagher and texted me as such. He said, just left voice message for city attorney that my letter can be released by the city as public information. You may be able to use this text to read to the PC. Nearly 3 years ago, the Lee House purchased their dream property on Brush Creek Road with a 1,836 square foot house to raise their young family. They wished to add a simple 300 square foot bedroom and bath to this modest home. In 2019, they consulted with experts, including some at the city and other experts, and were assured the information shown on sheet 4 of the final parcel map does not govern, but that city code, the zoning code, governs building envelope and setbacks. This was all, as Andrew said, during shelter in place. The Lee House had no prior experience with building a home or seeking permits. As explained in my letter submitted yesterday and in his submission, Dan is not a general contractor and does not have a contractor's license. The Lehows were given misinformation by a neighbor who told Dan that they did not need a permit up front, that the city was very busy and was not even issuing permits, and that they could build the addition according to code and obtain the permit afterwards. This seemed logical to the uninitiated. Once the addition was nearly complete, the complaint to code enforcement was submitted. Planning then determined the addition meets city requirements, and the Lehows submitted a comprehensive 65-page application adhering to the as-built process, paid the fees, and agreed to pay the in lieu mitigation fee of $2,600. The status of the addition at the time it was halted, left it partially complete and unusable. Among other things, the shower is not complete and the floor is not installed. Now we're at the point of this appeal. The addition, as we have heard, does comply with the zoning code. The tree removal ordinance was correctly applied, mitigation correctly applied, and Tony Cabrera will further address that issue. I do want to address one issue brought up in the late correspondence related to questions from the commission. The appellant asserted outside of the appeal, and the applicant had not been privy to this claim, that the addition and tree removal may have caused some root damage to an oak tree. I would submit that this is a private matter between the neighbors and not an issue on which to base a decision on this appeal. Finally, and not to belabor the point, I want to just quickly address what I found the distressing overall tone of appellant's attorney's 25-page letter submitted a few days ago. Contrary to Mr. Skelton's attempts to discredit the Lehows, they are honest homeowners who work hard in our community and surrounding counties. Amber is a nurse who has been on the front lines of this pandemic for over a year. And Daniel is a Napa County sheriff who has served 4 tours of duty in 2 wars and earned 2 Purple Hearts for his service to this country. At the same time, they are raising 2 young children. They did not engage in some sort of premeditated scheme to get away with not following city codes. They were giving misinformation by a neighbor, reasonably relied on it, and erroneously and innocently acted thereupon. They are now paying dearly for that mistake. In his letter, Mr. Skelton also insults city staff. City staff have done an outstanding and meticulous job processing this matter, and as mentioned at the outset, spent an excessive amount of time on a bedroom addition. Finally, Mr. Skelton levels accusations Tony Cabrera's way. Tony could speak for himself, but he has done his job as a consultant to the Lehows completely honorably and above board. To conclude, the Lehows are in agreement with and support staff's recommendation to deny the appeal so these people can finally complete their home. Thank you.
Thank you, Ms. Oya. Mr. Cabrera?
Yes, good afternoon, Chair Weeks and Commissioners. I want to cover a few items contained in Mr. Skelton's letter that he submitted March 22nd, just 3 days ago. But first, I'd like to commend staff and thank staff for their work and their efforts on this project. I'd like to commend them for their professionalism in which they worked through the process, and I'd like to thank them for being available and responsive during the process. And lastly, I'd like to thank them for their patience with me and all my questions. Regarding the trees, in Mr. Skelton's letter, he refers to City Code Section 1724 titled Trees, and specifically asked the Commission to reflect on the declaration of the legislative intent and purpose of this code section, which is to protect trees. The code section goes on further to state, recognizing an individual property owner's right to utilize his or her land in a way that is otherwise allowed by law. The tree removal is allowed by law, evidenced by the existing city policy and procedures addressing tree removal and code section 172405 that is titled Permit Category 2 Tree Alteration, Removal, and Relocation. Regarding the front yard setbacks, Mr. Skelton references both the city code and the conditions of approval of the original subdivision dated June 21st, 2000. He specifically highlighted condition number 3 in one of his 275 exhibits he submitted along with the letter. The condition states that building setbacks shall be shown on the local agency sheet of the final map. Condition 3 goes on to state, front setbacks for one-story structures shall be 50 feet from Brush Creek Road and pavement. Mr. Skelton refers to the code section regarding setbacks and specifically the measurement of setbacks. This code section he refers to states, a required front setback shall be measured by the most restrictive of the following methods to the nearest point of the front of the building. It is obvious and unquestioned which is the front wall of the building. It's where the front door is. Regarding the information sheet on the map, Mr. Skelton makes several references to the Subdivision Map Act and Government Code Section 66434. That discusses additional information that may be contained on the final map. Mr. Skelton asserts that certain information is required to be on the map and on the information sheet. What he fails to note is the code section states a city or county may, by ordinance, require additional information. It goes on to state that the information shall be in the form of a separate document or an additional map sheet. Mr. Skelton states if the statement wasn't included on sheet 404, the map would have been rejected by the city engineer for failing to comply with the Subdivision Map Act. Obviously, the statement was included on the information sheet, and the map did comply to the Map Act because the city engineer did sign and approve the map was recorded, and properties have been sold based on that map. Lastly, I must address Mr. Skelton's accusations of conflict of interest. He states that I am influencing and manipulating staff. This is insulting. This is insulting to staff. It is insulting to staff's integrity and professionalism. Staff has done nothing but conduct themselves in a professional manner. The city is fortunate to have people of such integrity working for them. And just to be clear, Andrew Triple, the project planner, was not employed by the city of Santa Rosa during my tenure. Thank you, and I'm available for any questions.
Thank you, Mr. Cabrera. So now we will go to the appellant for their presentation. And once again, you have 10 minutes. Not sure who's speaking. Mr. Skelton, are you speaking for the appellant?
I am, yes. And may I ask staff to authorize share screen, please?
One moment.
Thank you.
Chair Weeks, if we may have just a couple of moments. We have not procedurally allowed for the applicants to do a share screen in the Zoom environment. So if we can just have a couple moments to resolve this.
Would you like to proceed with that? Just take a 5-minute break?
That would be great. Thank you.
Okay, 5-minute break, everyone.
Thank you.
We'll be back at 4:36. Mr. Rose, how are you coming?
Chair Weeks, we're ready to proceed.
And start your videos. Thank you. Okay, so Mr. Skelton, would you like to proceed? As I mentioned, you have 10 minutes. And I'll give you like a 2-minute warning when it's coming up on that time, if that's okay.
So, Mr. Skelton, this is one of the hosts. We're going to promote you to a panelist, at which point you'll see the neon share screen square at the bottom. And if you need any help from there, let us know. And if you can keep your video off to stay consistent with the applicant, we'd appreciate it.
Sure, no problem. Commissioners, are you able to see the image on the screen?
Yes.
Perfect.
And just note that we're starting your 10 minutes now.
Okay, thank you, Commissioners. My name is Chris Skelton, and it's my pleasure to appear this evening or this afternoon on behalf of the appellant. So I want to make clear, first of all, my absolute respect and appreciation for the applicants, their service to the community, to the country, and I hope that none of my comments or written materials take away from that. This is not a neighbor dispute. This is not a popularity contest. One of the comments that was raised by one of the representatives is correct. I do take issue with the process and the decision that staff rendered. There is a process built into the municipal code to afford residents relief from those circumstances, which is what the point of today's appeal really is. Again, it's not an issue with one neighbor versus another, but really focusing on staff's decision. So there are two aspects to this decision. First, I want to touch on the heritage redwood tree removal, the fact that there's insufficient mitigation and that there were procedural deficiencies. And then I'm going to segue into the unpermitted illegal home construction. And the reason for starting with the redwood tree removal is the decision there may influence an outcome for the second issue. This is the tree at issue. It measures approximately 70 inches in diameter, 55 feet tall. So Mr. Triple on November 23rd in his email to the building official identified two different potential mitigation pathways. The first is mitigation with an approval, rendering a $2,600 mitigation fee. The second is mitigation or an in lieu fee without approval. And somehow or another, the decision landed that this tree removal, heritage tree removal, would fall within that first category of approval. Now, that's inconsistent with a lot of the literature that's been published. Here, from the late correspondence that staff rendered to the commissioners, it specifically says the director reviewed the unpermitted tree removal, meaning it was not previously approved prior to taking it out. It seems like that would fall into that second category. Again, in that same literature, it says the unpermitted tree removal is addressed in the enforcement classification. This article classifies unpermitted removal as a misdemeanor and provides procedure for processing a violation. I believe that we should fall within that enforcement, but the reason I share this context is it is consistently referred to as unpermitted and not approved. I want to walk through a timeline here just to provide a little bit of color and context. The tree was removed in October of 2019. September 1st of 2020, the building official informed the owner applicant, the appellant, that a heritage tree removal is referred to the city attorney for permitting. You can see here in that email at the bottom, it says, the matter of a tree removal without approvals has been referred to our city attorney's office for input. Again, as early as September, staff was referring to this as a tree removal without approvals. Therefore, we should not be in the first category. We should fall at a minimum in the second category that was first identified. September 17th, the city issued a notice of violation and provided a copy of the tree ordinance. Here is a copy or an excerpt of that section. Importantly here, it says the owner shall be denied for a period of 2 years from the date of the city's discovery any approval or permit which would otherwise might have been issued by the city for development or further improvements to the property. It's really important to understand the timing here. The tree was removed 6 months before any building commenced. I cannot reconcile how this is being positioned as a tree removal in pursuit of development when no development plan was established at the time of permit of tree removal. Moving on to September 18th, the builder issued a statement to the city clarifying and justifying the removal. It says specifically, our initial concerns with the tree were root systems that were encroaching on the existing foundation, as well as causing damage to the existing shingles. It goes on to identify it was recommended that we have the tree removed, which was completed in October. Nowhere in the record has there been a submittal from a home inspection report at the time of purchase or a roof inspector or anyone like that that confirms these issues. And I please don't take this the wrong way. I'm not calling the applicant a liar. I am simply asking that the city demand documentation to support what are inevitably self-serving contentions. September 22nd, Mark requests an arborist report, and Andrew confirms that in a separate email, that those are requirements. Mark's email says, submit an arborist report on the health of the tree. Andrew's letter goes on to say, we need these things, preferably by a certified arborist, but at a minimum, the company that removed the tree. I really can't accept tree data submitted by your husband, this to the applicant. On the 24th, an unknown, undocumented letter was submitted claiming to be the arborist report. This, as I'm sure the commission has seen and reviewed arborist reports, this does not qualify. This was produced as part of the public records that we received. This is the exact same document, no identifying information. But now, instead of it being based on root intrusion, it's posing a fire hazard. So the goalposts are shifting, if you will. October 7th, there's an email exchange between Mark and the builder regarding this arborist report. Mark writes, the paperwork submitted for the removal of the redwood tree is incorrect. The report as to why the redwood tree was removed must be on company letterhead, meaning that the arborist that had removed the tree needs to have the report on his letterhead. This is the second request. To this, the applicant responded, I've had extensive contact with the arborist and owner, and although he did write us a letter with your office's requested information, he's not able to sign his name because he did not personally see the tree prior to it being cut. He said he's willing to talk to whomever regarding the situation, but won't be able to sign for the provided information because it was his employee, parenthetically, and father, that cut down the tree. I find this very confusing that the person who is writing the report did not see the tree, yet the report is claiming that the tree presented a fire hazard. A fire hazard is an ANSI standard, and that is, I think, nothing to take lightly. So we want to make sure that qualified professionals are providing these opinions to residents in the community. Moving forward, October 30th, 2020, there's a letter from the engineer opining on the tree removal. It goes on to say that the gentleman that removed the tree felt that it posed a fire hazard and a safety for existing house and people who may be using the yard. I don't mean to get legalese on the commission. This is called hearsay. The engineer doesn't know this personally. He's passing on information that appears to be regurgitated from the same unidentified source. And now there's a third potential justification for the removal, which is it presents a safety hazard for people using the yard. Moving on, November 16th and November 23rd. These are email communications within the city, basically identifying that the tree removal has been approved. Andrew's email, which copies the city attorney, says, when I talk to the complainant and explain the realistic approvals, should I explain that when submitted, the application will be approved and no moratorium will be set on the property for 2 years for the application? If she wishes to appeal, can she do this to the director? I'm anticipating a bit of a conversation.
Mr. Skelton, you have about 2 more minutes.
Okay, I'll hustle through the rest of this then. You can see by Andrew Tripple's letter, he says in the interim, and he identifies, he doesn't even have an arborist report specifying the tree and the imminent hazard, but he's still going to approve the tree. This is on November 23rd. At a minimum at that point, this should have been allowed to be appealed prior to submitting of the building permit. So I've identified the various flaws. Notably though, this was done before any building was contemplated. There are 4 specific findings that need to be made under that separate condition. No qualified arborist report has been produced or given to the city. There's 3 varying justifications that seem to shift depending on the time. And I want to go back to this building permit cannot be approved because of the enforcement under 1724-140, which requires, and it does say shall. It doesn't say may, can, could be. It says shall be denied for a period of 2 years. Moving on, this is about the building. So I've exhaustively identified this, but I want to run through the 3 major issues. The parcel map, the zoning standards, and the building envelope. I'm going to fast forward and skip through the conditions and highlight really the zoning code because this is an important sort of intersection. So the zoning code defines front setback. You heard from Mr. Cabrera that he wants to define front setback as where is your front door. Unfortunately, that's not what the municipal code says. The municipal code says the front setback shall be across the narrow dimension of the lot. Staff has gone to great lengths to say that this original parcel map was a moment in time. We don't look at the parcel map anymore. We look at the municipal code as it exists today. So as we look at the municipal code today, we need to take the language which says front setback is the narrow dimension of the lot. On the original lot, to the right of the screen, you can see what it looked like pre-subdivision. On the left, and you can see the narrow portion of the lot is the portion abutting Brush Creek Road.
Mr. Skelton, can you please wrap up?
Yeah, absolutely. I'll just highlight this point because I think this is really important and then I'll close. On the left is the new resulting parcel for lot 3. You can see that the northern section at the top is the narrow portion of the lot. On the right here, I have a chart for you giving the lot dimensions. The north dimension is by far the narrowest. Now, you don't have to be a mathematician or a geometry specialist to understand that this is not a perfect rectangle. If you wanted to extrapolate this out, you could say, well, what's the aggregate linear footage between north and south and then east and west? And you'll see north and south, when aggregated, are less than the east and west. If you were to divide it by 2, you would get the average. It would also be less. And so no matter how you slice it, the north side is really the front setback. And because of that, the front setback is measured from the most restrictive area, and that is defined by the edge of easement under the zoning code. If we are totally disregarding the parcel map, and I know that's the direction staff wants to go, and we can accept that, although I disagree, and I've outlined why. But if we accept that as true, then the measurement for front setback is from that easement line. And right now there's a 3-foot distance based on this new addition, whereas the code requires 20. Therefore, you cannot make the finding that this addition complies with the development standard. If you want to deny that this setback, that this is the front setback, and you want to use Brush Creek based on that subdivision map, well, then you need to accept all the conditions of the subdivision map. You need to accept the building envelope and all those other conditions that I've outlined in my letter. So with that, I will close, and I will just share that there are many other examples of subdivision maps, parcel maps in and around this area where there are building envelopes that deviate from the development standards. If you use Google Satellite and overlaid it, all of those properties were developed in reliance on those building setbacks, and development should continue as such.
Thank you, Mr. Skelton.
Thank you very much.
Now we'll go back to the property owner for a 5-minute rebuttal. Ms. Zoya, is that you?
Yes, it is. I have just a couple minutes here,
Okay.
and then I don't know if Mr. Cabrera has anything to add. What I'd just like to say is the fact that the tree was removed a few months before the addition does not establish it has no relation to the development. Whether there were other concerns with the tree does not, excuse me, make it mutually exclusive from the construction of the addition. We appreciate Mr. Skelton backtracking on the accusation leveled against the Lee House. It remains that in his letter, he did call Mr. Lee Howe duplicitous, which means deceitful, and the Lee House are far from that. On the hearsay comment, hearsay is an evidentiary ruling that in my 30 years of doing this, I have never seen enforced in an administrative hearing. As explained in my recent letter, a moratorium doesn't make sense here. The addition is built and is proceeding on an application for an as-built. Imposing a 2-year moratorium would presumably require the demolition of the addition, which is a penalty extremely out of proportion to the quote violation. The addition remain empty for 2 years, which is also a remedy that is out of proportion and realistically unworkable. It further could lead to an unmaintained and potentially dilapidated structure attached to the original house if it had to be untouched. In sum, basically, we have heard nothing new outside of Mr. Skelton's letter. Staff has meticulously applied the development standards and concluded the addition complies. And I would reiterate our request that the appeal be denied. Thank you for your time.
Thank you. I think we'll, Mr. Skelton.
Chair Weeks, if I may, I just wanted to say Mr. Skelton did run a little long on his time, so we can add that back to the applicant's presentation or their rebuttal. So it would be an additional 3 minutes if they choose to use it, and they're not obligated to, of course.
For the appellant? Is that what you? The applicant. Okay.
Yes.
All right. So, Ms. Zoya, do you?
No, thank you so much. We appreciate that, but we have made our position clear. Thank you.
Thank you. Okay, so now we'll go to planning commissioners for any questions that you may have of staff or of the, Mr. Rose, can you come back on screen and guide me for a minute? This would be a time when the commissioners could also ask the applicant as well as the appellant questions, or is this the time when the commissioners would ask staff questions?
Well, you have options. You can do that. You can ask staff. You could ask the appellant, the applicant, if you have questions. You can also remember this is for public comment as well. So you can public comment if you so choose. That might then inform further questions. So it might be a way to hear the full testimony, and then you can go into your question and answer period.
Okay, thank you. I will go ahead and do that. So this is, we'll go ahead now and open public comment on this item. If you, find my script, just a moment. Okay, so if you wish to make a comment via Zoom, please select the raise hand button. And if you are dialing in via telephone, please dial *9 to raise your hand. And each speaker will have 3 minutes. A countdown timer will appear for the convenience of the speaker and the viewers. Please make sure to unmute yourself when you're invited to do so, and your microphone will be muted at the end of your 3 minutes. Mr. Host, do you see any raised hands?
This time we only have the appellant raising their hand, which is not the appropriate time for them to speak. No other members of the public are raising their hands at this time.
Okay. Okay, so we'll go ahead then and close the public comments and bring it back to the commission and open up to the commission for questions. And I believe Commissioner Duggan, you had a question?
Thank you. Yeah, I've got a question, I think, for staff, maybe Mr. Oswald. The appellant attorney mentioned a front setback and how it's applied and how it's determined. So at the time of the original parcel before subdivision, the narrow part of the lot was across Brush Creek, and the existing house that was modified, the Lee house, that was the front setback when that house was built, correct? And so now they're saying it's the narrow part of the lot, so it shifts to the north property line. So do setbacks ever change like that? And or can you have two front setbacks or two side setbacks? You know, like how does that work? Practically, you have an existing house.
Yeah, I'll take kind of the first crack at this. I'm going to turn it over to Andrew. I think he can give a little bit more detail. I also, before I get into that though, I wanted to mention, you'll probably see some of the additional staff we have available tonight. So Jesse Oswald, our chief building official, is here. We also have Gabe Osborne. He's the city's deputy director of engineering. So he's here as well if any questions come up related to the map. And Jesse, as our chief building official, is the director of our code enforcement team as well. So just very quickly, and as I mentioned, I'll turn it to Andrew for setbacks. When we talk about the narrowest property line, I believe this section of the code refers to the narrowest street facing property line. So there is a distinction there. So with that, I'll let Andrew summarize the measurement and how we determine the setbacks, or which property line is which.
Great, thank you, Mr. Rose. Commissioner Dugan, so your question again was how were the setbacks established and then applied?
That before the big lot was subdivided into 3 parcels, the narrowest part of the lot was the frontage that faces Brush Creek, and then the front of the house faces Brush Creek. And so now Mr. Skelton is saying because the parcel was subdivided into 3, the narrowest part of the lot faces north, faces the private drive, so that is the front setback. And I'm asking, can the front setback change like that? The house was existing, it was appropriate that it was a front setback when it was one house facing Brush Creek, and that was the narrow part of the lot. And so as far as setbacks, can they shift like that, and what's appropriate?
Sure, great, thank you, that helps. So when we began review of the application after determining that the building setbacks shown on the supplemental information sheet were not enforceable, we then turned to the zoning code to establish the setbacks. The setbacks section does indeed say that, well, let me go back. The zoning code would define the front lot line as being that lot line that separates the parcel from the public right-of-way. It would define that the front lot or the lot frontage as that portion of the parcel that fronts the public right-of-way. So we have there, when we look at the parcel lines and we apply definitions to the parcel lines, then we would have the front parcel line being that parcel line that is adjacent to Brush Creek Road. Then the north and the south parcel lines being interior or side parcel lines, and then the eastern parcel line being the rear parcel line. Then when we go over to the setbacks section, the setback section interestingly says that the front setback is determined based upon the narrowest dimension of the lot, which would seem contrary. You would expect the zoning code to define the front setback based upon what it's defined the front property line to be and the lot frontage to be. So it is interesting that the zoning code says then that the frontage is determined based upon the narrowest portion of the lot. However, that section also allows the planning director to make a determination of the front lot line otherwise, or the front setback otherwise, I should say. So for the purpose of applying the zoning code, the required setbacks from the R115 zoning district, we determined that because the house faces Brush Creek Road, and because the Brush Creek Road parcel line is the front parcel line and is defined as the lot frontage, that the front setback is established as being a minimum of 20 feet from the Brush Creek Road public right-of-way. Except that then when we apply the setback required through the Scenic Road Combining District, it would require a minimum of 50 feet setback from the edge of pavement of Brush Creek Road. So at the end then, we did make the determination that the front setback is established as being that frontage along Brush Creek Road. Then the north and south property lines would be subject to a 10-foot interior side setback. And then the east property line would be subject to a 20-foot rear yard setback.
Okay, are there other questions for our staff or the, I do have a question, and it's regarding 17.24-140 about the tree removal. And if you could kind of explain that to me about why that's not applicable.
Sure. So when in working with code enforcement and with buildings to address how the code violations would be considered and what code enforcement, what the city would require for legalization or resolving of those code violations, we did of course recognize that there was a tree removal that was not permitted and that there was unpermitted construction. However, we made the determination or we viewed the project as the tree would not have been removed had it not been for construction of the addition. Therefore, the tree removal was part of proposed development. And so when we reviewed then the building permit application, it's standard for buildings and planning when tree removal is proposed for development and no other permit other than a building permit is required, then we review the tree removal as part of the building permit application, approve or deny, and if we approve the removal, then we require mitigation as part of the building permit application. And that was the approach that we took in this project as well.
Thank you. Any other questions for staff? Okay, seeing none, then, oh, I'm sorry. Sorry. Commissioner Holton, sorry.
No, thank you. I'm just a little curious as to why there really was no arborist report and why the repeated requests for an arborist report were ignored, or not ignored, but not complied with.
Sure, that's a great question, Commissioner Holton, and thank you for asking that. If the purpose of removal of a tree was because the tree's health was damaged, the tree was suffering and needed to be removed because it was dying, then we might require an arborist report to corroborate that and to support that request for removal, if there was no other reason for removal, if that's the stated reason. In this particular instance, the reason for removal is for development, for the addition of the parcel. And additionally, then the property owner cited safety concerns related to the proximity of the tree to the house. I did request an arborist report because I didn't know if they had consulted an arborist prior to removal of the tree. When it was clear that they had not consulted an arborist, that's when I responded and said, well, I need something. I need a professional to provide me with data about the tree that was removed. First of all, so that if we do authorize the approval or the removal of the tree, we can then mitigate it. And so Mike Robertson submitted a letter, and this was the letter that Rosa referred to as being redacted in her letter to Planning Commission. And in that letter, Mike Robertson is a licensed professional, and the letter was stamped and signed using his professional certifications. And in that letter, he did fully describe the tree. He described the proximity to the house, and he described and reported on the safety concerns that both the tree removal company had as well as the property owners had. So for that reason, then I did accept Mr. Robertson's letter as sufficient for a description of the tree and of the situation.
Are we privy to any of that information from that report?
Yes, that report is available as attachment 12 to the meeting item. Okay. I believe it's entitled Tree Mitigation Letter.
Okay.
Or Tree Removal Documentation, rather.
Okay. Thank you.
Sure.
Any other questions? Vice Chair Peterson? I'm sorry. Ms. Gallagher?
Yes, if I may, Chair Weeks, I did want to confirm, I know Ms. Zoya mentioned, I did receive a voicemail from Mr. Robertson, who did authorize release of that information. And so if the commission desires, that can be read into the record. And I don't know if the attachment, I have to pull up whether the attachment was unredacted. I don't know.
Madam City Attorney, the attachment 12 was not redacted. The redaction was done as part of, I believe it was attachment 8, property owner correspondence.
Okay, thank you.
Thank you. Vice Chair Peterson?
So there's a lot of words in front of us. So I want to, if I take a moment, please indulge me. So I want to kind of circle back to the specific grounds for the appeal that was filed. So on the heritage tree front, the appellant disagrees with Planning and Economic Development's determination that the tree would have been approved for removal in accordance with the tree ordinance. So looking at the tree ordinance, does the planning director or whoever have the discretion in general? So if they had filed for a building permit, does the planning director have discretion to authorize the removal of a heritage tree?
Yes, so I'll take that, and the answer is yes. I think that, and thank you for framing that, Vice Chair Peterson. The action before the commission is an appeal of the director's determinations on a building permit. Mr. Triple just indicated that he reviewed this, he made some determinations, and it is actually the director that makes the determination. And in this case, it was in consultation with a number of city staff. So on all of these issues, we've reached out and worked with the city attorney's office, the engineering department, the building department, and so on. But with regard to trees in particular, the zoning code gives the responsibility and the authority to the director of planning, to enforce a number of things, obviously the general plan, the zoning code, and things of that nature, but also adherence to and consistency with the tree ordinance, which falls in chapter 17. So the zoning code is chapter 19 of the municipal code. The tree ordinance is chapter 17, but this is where the zoning code gives the director discretion or authority to implement, enforce, ensure consistency with chapter 17, the tree ordinance. And in this instance, that's exactly what happened. We evaluated it. And just to back up for 1 second, there were a number of email references. They were tied to the timeline. And as I'm sure you all can appreciate, this type of a project evolves over time. So as we consult with other staff, as we gain more information, we make our determinations based on the information we have available to us. So as Mr. Triple said, we did rely on information from Mr. Robertson. We also relied on our own evaluation as well. And so the conclusion is that this came before planning as a building permit. We reviewed it as development, and we cited that section in the tree ordinance that allows us to authorize that tree removal. And then just to support further Mr. Tripple's assertion that we felt that it wasn't necessary to go further with an evaluation, the typical arborist report for the health of the tree, because we knew why the tree was being removed. You could assume the tree was healthy for sake of argument. It was being removed to accommodate the development. So that was some of the thought process and how we reached the conclusions that we did.
And my understanding, please correct me if I'm wrong, is again, in that process, the planning director is part of that discretion, can say, you know, put a bunch of trees, put fewer trees, pay a mitigation, you know, into the tree fund. That they're you know, we're not dealing with a you know, one size fits all kind of ordinance here. That there is some play and back and forth. And specifically what I'm thinking of is the letter that I think may have already been referenced about, you know, we mapped it out and 26 trees probably won't fit if they're redwoods on a lot this size and things like that.
You're absolutely correct. That is the practice that we take on permits of this nature and how we assess what's an appropriate replanting plan, or in some instances, payment of the in lieu fee. And then if I can keep going, the sort of the second ground for the appeal is a dispute about the building setback lines and sort of which controls and what role, if any, the supplemental sheet has as part of the final map. So again, in reviewing this is another sort of planning director kind of question that it's, you know, we've heard pretty extensive, you know, discussion of how setbacks are determined and where they fall. And so again, the heart of the matter is what role the supplemental sheet plays in the final map. And the conclusion that planning reached was that it is a reference, but not the controlling document. Am I kind of hitting the mark here? Yeah, you've got it. And I think what's partly maybe a little bit confusing is that some of the terms that are being utilized. So in the world of planning and development, a building envelope and a building setback mean different things. And where those building envelopes and or setback references occur mean different things. And so as you've heard, when a building envelope or setback for that matter is referenced on the supplemental sheet or the information sheet of a subdivision map, then it's for reference purposes only. It does not have title interest. So in that case, we refer to zoning. We went through the analysis that Mr. Triple indicated in terms of figuring out which is the front and the side and the rear property line, and we apply what the zoning district requires for setbacks. And we also have Gabe Osborne, as I mentioned, if you'd like to have more discussion on the Subdivision Map Act and how the supplemental sheet is to be evaluated, we can go into more discussion about that as well.
All right, well, I'll turn it over to fellow commissioners, at least for now. I may have some questions depending on what else comes out.
Are there any other questions for staff at this time? So Vice Chair Peterson, do you want to take another crack?
Sure. So again, I guess this is kind of more of a procedural question than sort of what I've been asking, I guess. So again, we've got in front of us planning director's decision on 2 items that were appealed. So as we're hearing this appeal and we're looking at this decision that was made by the planning director, we're more, okay, so correct me if I'm wrong. We're trying to determine whether that complied with kind of the objective standards or the regulations that the city has in place for things like the building permit process or the heritage tree removal process. Is that correct?
That's correct. So what's before you is the subject of the appeal and what's contained within the actual appeal itself. And what that focuses on largely is whether or not the director appropriately applied setbacks and appropriately applied setbacks relative to a subdivision map. And then did the director of planning appropriately apply proper tree permitting and associated mitigation on a building permit.
Okay. And so based on what I've heard, then what I'm looking at from where I sit is we're not trying to decide whether something is good or whether something, you know, I don't know, is equitable. What we're trying to figure out is, was the process followed? Did those objective standards get put in place? And did this particular project meet those objective standards?
Very accurate summary. A building permit came before us in planning. We evaluated it. We evaluated, as I mentioned, in considerable consultation with all of our partners and colleagues in different departments, the relevant departments throughout the city, and we made the conclusions that we've indicated.
Okay, thank you.
Okay, so any other questions? If not, if somebody would like to
Chair Weeks also,
no.
if
Yes,
the commission had any questions of either the applicant or the appellant team, you're welcome to present those as well at this time.
Thank you, Mr. Rose. Are there any questions of the applicant or the appellant? Okay, seeing none, then if somebody would like to make a motion?
I'll move the resolution of the Planning Commission of the City of Santa Rosa denying an appeal and upholding Planning and Economic Development Director determinations made during planning review of building permit application B20-6871 for modifications to the property located at 1900 Brush Creek Road, assessor's parcel number 182-140-056, file number ST20-003, and waive further reading.
Thank you, Vice Chair. Is there, excuse me, is there a second?
Second.
Okay, thank you, Mr. Okrepke. That was moved by Vice Chair Peterson and second by Commissioner Okrepke. We'll go around and do further comments. If you have those, we'll start with Vice Chair Peterson.
Sure. So my comments will be a little bit of a retread of sort of where my questions went. This is one of those things that sort of procedurally is a little interesting in that, you know, normally the building permit process is not before us. And so as I review this, you know, looking at the specific grounds for the appeal that were filed by the appellants and the specific process that was followed, sort of taking them in turn, I think that the final map and the setback issue has been very extensively briefed, and I find the conclusion of the Planning and Economic Development Department to be compelling. I think that based on the standards that we have seen and that have been put in front of us on how these setbacks are determined and whether or not the specific building that is in existence is within those setbacks, I think that is correct. I think that the process in a procedural sense was adequate and followed the rules set forth by the city and the various state acts as they may apply. So I have no issue with the decision made by the planning director on that front. And then on the tree removal portion of it, you know, again, going back to my question, just sort of procedurally, it makes sense to me that planning and economic development, the planning director would determine that this was a tree removal made as part of a building permit process. May not have been in effect at the time of the removal, but I'm not sure that I don't find that particularly relevant to the determination of what's in front of us. This is a discretionary kind of decision by the planning director. And, you know, I just sort of frankly don't see a reason to treat it as anything other than a tree removal as part of the building permit. I mean, we've had no evidence that, for instance, this tree removal was going to happen of the addition being created. So again, on the specific issue of the appeal, whether or not the planning director's decision was procedurally adequate and followed the objective standards, I agree with it. And just so on those two grounds of the appeal, I support the determinations made by the Planning and Economic Development Department. I would support the denial of the appeal of those decisions. And, you know, just as kind of a general matter, I think we've heard a little bit about it, but I understand appellant's concern. I understand that the arguments, you know, about equity and, you know, why have a building permit process if it doesn't get followed and nothing happens as a result. But I think that that's, one, not necessarily accurate. I mean, I think that, you know, making mistakes happens, and the idea that the punishment for the mistake would be anything having the building permit process. You know, I don't know. It seems kind of hard for me to swallow that. You know, a mistake was identified. The process has now been followed. We've got the appeal in front of us. That's the specific issue. And so, as a general matter, I find just sort of the overall process to have been adequate. And I'll turn it over to my fellow.
Thank you, Vice Chair Peterson. Commissioner Carter?
Well, it's hard to add anything more to the discussion based on what we've heard today. I tend to agree that the application of setbacks in this particular case do make sense as interpreted by staff. The removal of the redwood tree, I think, would have been approved as part of a development application, so that makes sense. The difficulty is that it was done before the application process proceeded, and I don't think the applicants made any points for themselves by recounting the problems of the tree on the existing structure. But I do accept staff's assessment that it would have been approved as part of a development proposal. We're looking at a minimal side yard setback on the addition, but I believe it does meet those setbacks as defined by staff. And based on that, I will be not supporting the appeal.
Thank you. Commissioner Dugan?
I'm also going to vote to deny the appeal. I don't have much to add except for the fact that the information that the applicant or the building owner has been given all along when they reached out with one of their representatives prior to this whole thing about would this addition be allowed has been consistent from the staff that back way before that they started the whole process. And also the fact that they claim that they were going to apply for a building permit all along, and that with all the photo documentation, one thing that confused me with all the documentation we were given was all the photos shown. If you were trying to do a legal build, you probably wouldn't take all those photos showing the whole process to use later to show the city that you actually complied with code and it was structurally and done correctly. So I am in favor of denying the appeal.
Thank you. Commissioner Holton?
Thank you. I can basically say Commissioner Carter pretty much wrapped up every sentiment that I wanted to express, and I too will be denying the appeal. However, I just wanted to say from my personal experience, I've done a lot of tree removals, and I also know that in doing so, it's a very impactful act to remove, especially a heritage tree. And so I'm a little concerned that maybe the punishment might not be what I feel it would typically be associated with something that I've personally experienced in the past in terms of removal of trees. But with all of that being said, you know, I just wanted to say that I think that I support the staff in their decision, and especially in regard to the setback, I 100% agree. I think that definitely was at their discretion. I just really had a problem with the tree being removed, and there was a lot of, this gentleman recommended that it was okay, and there was a lot of, so with that being said, I just remember what a friend of mine once told me, and that is, ignorance is no excuse for breaking the law. And so just going forward, just please keep in mind when making decisions to remove such an impactful, you know, part of your land, you know, just be mindful. And so I too will be voting to deny the appeal. Thank you.
Thank you. Commissioner Okrepke?
Yeah, most of my comments are just going to be concise retellings of what has already been said. I agree with the application of the setbacks in this case. I do believe the process was followed accurately and within the purview of the Planning and Development Department. And I do believe that the tree removal portion of this was also adequately followed. I understand the argument of if we have rules, why would we, and it's okay to break them, why do we even have rules? It's so you get it done the first time, get it done right the first time. I can speak from experience that the individuals named in here and participating, including Deputy Director Rose, Mr. Oswald and Mr. Osborne, I've seen them personally in the rebuilds correct things that were done very, very improper and force people to do things that were to comply. So it's not that they have some sort of power trip or whatever the accusation was to say that they have full autonomy and discretion to do whatever they want in this specific scenario. They're going to let this pass. They actually follow the rules, and I've seen it done personally with my own eyes. So that being said, I will support staff's recommendation to deny the appeal.
Thank you. I also will support the determination made by the planning director and deny the appeal. So, Mr. Maloney, do you want to call roll?
Definitely. So we'll do this in alphabetical order, starting with Commissioner Carter.
I believe that's a no to deny the appeal. Is that correct? No?
No.
Okay.
It's a yes.
It's yes.
Voting
yes
to
yes
deny
to the staff's
appeal.
recommendation to deny the appeal. Thank you.
Thank you, Commissioner Carter. Commissioner Duggan?
Yes.
Commissioner Holden?
Yes.
And Commissioner Kelly is absent. Moving to Commissioner Okrepke.
Yes.
Vice Chair Peterson?
Yes.
And Chair Weeks?
Yes. And so that passes, excuse me, with 6 ayes. Commissioner Kalia absent. And I think we'll go ahead and take a 10-minute break, or would you like longer? Mr. Rose?
I think 10 minutes is probably fine, yes.
Okay. So we'll be back at 5:44.
go back to the system. How about now? Can you hear? Test, test, test. Test, test, test. No, I'm just testing the audio levels.
Are folks ready to come back? Mr. Triple and Mr. Rose, is staff ready for us to continue?
Chair Weeks, we can't hear you.
Oh, you can't?
Showing you're unmuted. You might have to adjust your audio setting.
That's really strange because I can hear her.
Yeah, I can too.
Can you hear me now?
Yes.
Okay, thank you. I didn't touch anything, honest. Okay, so staff, are we ready to go to our second item?
Yeah, sorry, we're promoting the
Okay, thank you.
presenting planner right now.
Thank you. Mr. Maloney, do you need to call roll again after the break?
No, it's not necessary.
Okay. Okay, so If we're ready, we'll go on to our second item of the evening, which is item 9.2. It's a public hearing, conditional use permit, Alternatives East, 2300 Bethards Drive, Suite A, city file number PRJ 19-047. And this was continued from February 25th. And this is an ex parte item. So I will ask the commissioners if they have anything to disclose. Commissioner Carter.
I visited the site and have nothing further to disclose.
Thank you. Commissioner Duggan?
I visited the site and have nothing further to disclose.
Thank you. Commissioner Holton?
I visited the site and have nothing further to disclose.
Commissioner Krupke?
I visited the site and have nothing further to disclose.
Thank you. And Vice Chair Peterson?
I also visited the site and have nothing further to disclose.
And I also visited the site and have nothing further to disclose. So I believe our presenter tonight is Mr. Ross.
Yes, that is correct.
Oh.
Sorry.
Nice to see you, Mr. Ross.
You as well. Thank you so much, Chair Weeks. So I guess I will get started now.
Yes.
I'm going to go ahead and share my screen and start the presentation.
Thank you.
Oops. Can you see that?
Yes.
Okay, great. So thank you, Chair Weeks and members of the Planning Commission. My name is Adam Ross. I am a interim senior planner presenting on behalf of Susie Murray, the project planner for the Alternatives East Dispensary project. Before you today, as you stated before, it was a continued item from the February 25th regularly scheduled Planning Commission meeting. It allowed staff time. It was continued due to a discrepancy in the noticing requirements, for which staff was able to properly notice this public hearing pursuant to the required zoning code. The project includes, again, the Alternatives East project, which is a dispensary retail facility with delivery and approximately a 2,550 square foot tenant space of an existing 17,990 square foot building. The hours of operation are 9 a.m. to 9 p.m. 7 days a week as permitted in the cannabis dispensary requirements of the zoning code. There is no on-site consumption proposed with this project. The location is 2300 Bethards Drive in Suite A, that is in the southeast quadrant of the city of Santa Rosa within the Bennett Valley area. Here is an aerial view of the project. As you can see, it's on the corner of Yulupa Avenue and Bethards Drive. Bit of the project history. These are switched a little bit, but on December 5th, 2019, an application was submitted requesting the conditional use permit. On January 22nd, a neighborhood meeting was held to introduce the project. And on January 20th, 2020, the scope of that project was amended to exclude the on-site consumption area, which left it only with a retail dispensary with delivery. The general plan is office, and the zoning is office commercial, CO, which does allow a cannabis dispensary by way of a major conditional use permit, subject to the approval of the Planning Commission. Here's the site plan. As you can see on the north side of the property, which is on the, as I'm looking at it, the right side of the screen, where my mouse is hovering over the parking lot, there is the main entrance facing Bethards Drive with an entrance to the common area of the building. And then you have a vendor entry and staff entry in the back that would come in for a secured product location. However, let me back up for a second. So here's a blown up version of that floor plan. So as you see, here's that entrance to from Bethard's Drive and into the common area. There are 2 doors presented in the original floor plan. However, the Planning Commission gracefully pointed out the zoning code requirements for cannabis dispensary entrances be prominently displayed, or I should say open or viewable from the public right-of-way. So with that, what happened was staff's interpretation was that this did meet the intent of the zoning code, but as that was pointed out, further analysis required a bit of discussion with the applicant, and the applicant has presented a new floor plan, which then shows the entrance directly on Bethard's Drive. It would close out the existing entrance here to Suite A. So you have a little bit of reorganization of the interior for the check-in area. So then it would meet that section of the zoning code, which is 20-46.080D. There's also an elimination of a door into one of the office spaces for the Suite A. It was just unnecessary, so that was removed. The operation plan would still remain the same, where this is vendor access here. This is all limited access area, so this is the only area allowed for the public or customers to go into. The trip generation shows that with the delivery supported by W-Trans, a traffic engineering firm, would be 45 trips, peak hour trips, PM, which is less than the 50, which is the threshold for a traffic impact study. Traffic engineering with the city reviewed the application packet in its entirety, along with the traffic engineering trip generation analysis, the focus traffic study provided as part of the application package, and found it acceptable. The parking for a cannabis retail facility is one space per 250 square feet of retail space. And the most common commercial office use, in addition to that, is 1 per 250. So it's very similar to what it was already existing or previously existing at this site. So if you look at the building as a whole, the requirement is 72 parking spaces. Based on full occupancy, if you apply one space per 250 square feet of a 17,990 square foot building. The site was built out with a total of 63 parking spaces. So overall, the site exists with a deficit of 9 parking spaces. However, under zoning code section 20-36.040C, when a building's use changes to a new use without enlarging the space in which the use is located, there shall be no additional parking required for the new use, except that the new use shall comply with current ADA standards for parking, provided that any deficiency in parking is no more than 10 spaces or a 25% overall reduction from standard parking requirements, whichever is greater. In this case, this application does comply with this section of the zoning code. So you have 63 spaces. It's a new use from a similar use, and therefore no additional parking is required. So with that, I should specify that the project is compliant with parking standards for this site. There have been a lot of public correspondence, as you have seen in the application package, including late correspondence as up to this afternoon. There are letters of support and emails in support, as well as opposition to the project. Some of the opposition concerns are on-site consumption. That has been removed as part of the application proposal. The proximity to schools. The nearest school is 1,800 feet away, and the closest and the requirement is 600-foot setback from K through 12 schools. Traffic impacts. With that, there is a traffic impact study provided by a licensed traffic engineering firm that indicates that the impacts would be minimal to the site. They're a concern over parking deficit. Under code, this project does comply with the required parking. An increase in crime and concern over the business operator. So again, this is just a bit of what I've responded to. It's less than 50 peak hour trips. The closest school is Yulupa Elementary, which is 1,800 feet away from the project site. And the project does not include on-site consumption. Under the CEQA review of this project, it's found to be in compliance with the California Environmental Quality Act under section 15301, which involves minor modifications to an existing building. Section 15303, which involves a change in use of an existing building. Section 15332, which is an exemption for infill development, and 15183, which is consistent with the general plan. With that, the Planning and Economic Development Department recommends that the Planning Commission, by resolution, approve a conditional use permit to allow a cannabis retail facility with delivery service at 2300 Bethards Drive, Suite A in Santa Rosa, with the approval of the site plan submitted by the applicant today. And I just wanted to reiterate that any conditions to highlight that are available to you as well. That concludes staff's presentation. I'm here for any questions you may have, and the applicant has prepared a PowerPoint presentation for you as well.
Thank you, Mr. Ross. Let me just ask a quick question. With the change to the site plan, would the resolution need to be amended?
Let me just ask for, I think Bill's going to answer that.
Yeah, I think just to make sure for accuracy in the record, we should make a reference to that.
Okay.
It can just, if there's a motion, we can give you that language. It would just be by reference, site plan dated received, and we'll get some kind of specific language ready for you.
Great, thank you very much. Okay, so the applicant, not sure who's going to be making the presentation for the applicant.
That would be Karen Kistler, and I'm going to go ahead and share my screen and open up their presentation.
Okay, so you have 10 minutes.
Thank you. Ladies and gentlemen of the Planning Commission and community, my name is Karen Kistler, Director of Alternatives, and I'm so excited to tell you about our application for a second dispensary on the corner of Bethards and Yulupa in Bennett Valley. Looking at the first slide, you can see from the corner, it's a standard commercial office building, about 17,000 square feet. And we don't plan to make any changes to the outside so that it's consistent with the look and the feel of this commercial corridor that it exists in. Right now, there are 8 tenants in the building, and all of them support there's no opposition by the tenants to have a neighbor as a dispensary. On the next slide, one of the concerns addressed was the neighborhood compatibility. And we can see from this slide that it's a very intense commercial corridor that is compatible with a dispensary. It contains other uses of retail areas such as Ace Hardware, Safeway, Dollar Tree, CVS is right across the street. There are Pilates studios. There's an MD Wine and Liquor. There are many restaurants that hopefully are still hanging on. sushi and pizza, the great Italian restaurant. Right across the street, there's a wonderful architect and dentistry offices. And it's sandwiched between physical therapy centers. There's a Pilates studio in one of them, and there's a massage body working use in another of them. There's a gas station, catty corner with a convenience store aspect. So we believe that this dispensary is compatible with the uses around it. On the next slide, you see that the interior plan, as it has been altered for front door purposes, makes the front door visible from the street so that you have an entry point from two different angles, both in the public right-of-way. One of them is along the front of the building from the ADA parking spaces, and the other is from public parking on Bethards and also from Yulupa up the stairs. So you enter into a reception area that also screens people for their ability to enter, whether they're adult or medical patients with a valid California recommendation. And they walk into a discreet, well-appointed store. That also contains education stations. There are private consultation rooms. There are well-lit, discreet security cameras all around. And there is, of course, COVID-19 social distancing with masks required and frequent disinfecting. The next slide shows that the general plan of the dispensary is to provide consistency. We want to retain the neighborhood aesthetic. We are discreet, professional, and attractive. We're also consistent in that we, of course, only offer tested, safe, and affordable medical and adult use cannabis. And we provide an oasis to customers for them to be inspired to learn and explore the benefits of cannabis. On the next slide, Alternatives Dispensary has demonstrated its success in Santa Rosa. We are a thriving dispensary in its 12th year. We were one of the first 3 dispensaries to be honored with a permit in the city of Santa Rosa. And before that, before Roseland was annexed, we were honored to receive the county of Sonoma's permit. This company is 100% women-owned and operated. There are no outside investors, and we reinvest all of our profits back into our business and into the community. We have a proven track record of full state and local compliance. We've mentored dozens of people who are passionate to learn about the cannabis industry, many of whom are women and minorities. We innovated the first recycling program for used packaging. We hire locally and we give preference and support to local cultivators and family farmers, manufacturers and distributors. Such an important point, especially since the county is reconsidering its cultivation ordinance to expand allowable arable land for cannabis growers. And when that happens, they're going to need compliant outlets so that all the revenue that comes from their hard labor stays as much as possible within the city boundaries. We are California track and trace and Waymaster experts. Going to the next slide, thank you. Yeah, traffic. Right now at our hearing, we have Cameron Nye, who is a principal at W Trans, to answer questions about the projected 45 new peak hour trips. But we suspect that that's to be reduced by our delivery service. Currently, we provide delivery to the entire county, and with 2 cars that we can focus on the east side, we can serve our customer base much faster and more efficiently and ecologically by having some part of the delivery service operate from Bethards. Odors will not escape the shop. Engineers have approved our accepted and best available industry-specific technologies designed to effectively mitigate cannabis odors. And we have James York on standby today to answer any questions about escaping odors, but we have that under control. Crime. Dispensaries don't significantly impact violent crimes, and property crimes actually decrease according to the IZA Institute of Labor Economics and the RAND Corporation studies. And these studies ascribe this reduction to increased foot traffic and eyes on the street, even at extended hours. And on our hours would comply, of course, with the local code, opening at 9 and closing at 9 p.m. So it also ascribes this reduction in crime to increased security technology. Of course, we'll have state-of-the-art technology and availability of tested, safe cannabis without the stigma. So people will come to us instead of looking for other sources for their cannabis needs. There has been a myth that because we're a cash business, it attracts a criminal element, but in fact, we have conventional banking and checking and savings, and we accept credit and debit cards because of our long-standing and very successful presence in the community in our 12th year now. So looking at the next slide, about the applicant, that's me. I've been an attorney for 39 years, and I'm a mother of 2, a registered nurse and a teenager. I'm a stage 3 cancer survivor, and I've researched, because of that, the medicinal benefits of cannabis and devoted my career to learning about its properties and helping others. I own a home in Montgomery Village and commercial properties in Bennett Valley and Roseland. My contributions to the community include, was a member of the Roseland Steering Committee for Annexation, Santa Rosa Metro Chamber, active member, Sonoma County Bar Association, the Normal Legal Committee. I've a featured speaker at the Metro Chamber's Young Professionals Network, member of the Society of Cannabis Clinicians and the Jewish Coalition for Literacy. In addition to that, I'm OSHA certified and an approved state bar mediator. And in closing, I would, first of all, thank you so much for the opportunity to address you. Cannabis users are in every walk of life, every socioeconomic group, and every style of dress, music, color, field, and occupation. We are in the mainstream and in every tributary. Reflecting our new neighborhood, this shop will be clean, discreet, and attractive with no exterior cannabis signage and no consumption on the property. We're aware of some neighbors' concerns, and I will be the community liaison available 24/7 to answer questions and discuss any concerns that they may have. Thank you so much, and I look forward to this process.
All right, I guess I better unmute myself. Are there any questions for staff before we go to the public hearing? Okay, so then I would like to open the public hearing. And if you wish to make a comment via Zoom, please select the raise hand button. If you're dialing in via telephone, please dial *9 to raise your hand. Each speaker has 3 minutes. A countdown timer will appear for the convenience of the speaker and viewers. Please make sure to unmute yourself when you're invited to do so, and your microphone will be muted at the end of that countdown. So, Mr. Host, do we have anybody?
Thank you, Chair Weeks. Yes, we have quite a few, so I'm going to go ahead and list some names. One moment. First up, we have Elizabeth Hutton.
Can you hear me?
Yes, loud and clear.
Thank you. I'm a resident of Bennett Valley. I was distressed by the staff recommendation of approval of this application. It would appear that recommendation reflects a checking of the boxes as opposed to any real consideration of the merits. I trust the commission will drill down to seriously consider the defects with the application, the applicant, and the threatened harm to the neighborhood. The proposed use is inconsistent and incompatible with the neighborhood and the current use of the property. It is not similar. This is a sleepy, densely populated residential area where the building in question houses quiet offices. The property abuts a condominium complex with mixed residential uses in every direction. Directly across the street is a school bus stop. According to the ICMA publication, Santa Rosa intentionally directs cannabis businesses away from residential areas, in large part due to the increased crime caused by these businesses. This increased risk is well known by law enforcement. The proposed dispensary is smack dab in the middle of a dense residential area, noted for its safety. This is a business that is so dangerous it requires armed guards and extensive security systems. Ms. Kistler's own dispensary was robbed. This business imports criminal activity. This proposal flies in the face of the city's commitment to the safety of its residents. Also inherent in this application is the huge danger resulting from increased traffic. The applicant solicited a trip generation estimate from W-Trans dated 2/16/21, estimating generation of 546 new trips daily. Faced with neighborhood outrage at these eye-popping numbers, after a call from Ms. Kistler just 2 weeks later, the same expert's estimate plummeted by 80% to 120. The given reason for this revision was allegedly different data, claiming the first estimate was based on Colorado data and the new number on North Bay data. This excuse implodes as the first report contained no reference to Colorado and emphasized its reliance on Santa Rosa data. No intelligent person can view these numbers as valid. Ms. Kistler insults this commission by presenting them. This application has no credible evidence to support its claims as to traffic. Equally concerning is Ms. Kistler's intended use of the location as a delivery hub. She vehemently denies it will be a distribution center. However, this is a matter of semantics. So why should we be concerned about Ms. Kistler's representations? Judge Ottenweller concluded she is not credible, an assessment notably endorsed by the Court of Appeals. Her record in Sonoma County of flouting the laws affirms this concern. This same applicant offends this proceeding by buying public comments with 1-cent joints. This is someone who, when given an inch, will take the proverbial mile and keep running. Her credibility infects every aspect. If she gets her foot in the door, there will be no holds barred. And who will suffer? We, the residents of Bennett Valley. We ask that you deny this application. Thank you.
Thank you.
Thanks. Next, we have Kelly. And if you can please state your last name for the record.
Hi, my name is Kelly Carnegie. I believe that the new Alternatives East will be widely accepted by our community. The new location will save East Santa Rosa customers time, money, and most importantly, peace of mind. Many Bennett Valley community members use cannabis as a form of self-care and medication and want safe access to tested and reliable products. Alternatives offers discounts daily for seniors in order to service the elderly of Santa Rosa. The new location will keep elders' travel time to a minimum, helping to ensure a safer neighborhood. Less driving time for customers means cleaner air for all of us and for the quality of the environment. Now more than ever is the time to stimulate our local economy by inviting new successful businesses to open. Sales will help boost our economy and provide local jobs. Alternatives will raise so much in tax revenue and fees while keeping money circulating in our community. Alternatives is a complete fit for Bennett Valley because it's already has a lot of commercial area there anyways. Shop small. Alternatives is family and woman-owned business, and I support them fully. In conclusion, Bennett Valley community members use cannabis and deserve to have a safe and reliable way to obtain their products. There's no reason cannabis users should be excluded from business in this area. I ask that you approve this application.
Thank you.
Thank you, Kelly. Next, we have Christiana. If you can please state your last name for the record.
Acosta.
Thank you. You can go ahead.
Hi, so my name is Christiana. I highly support the opening of Alternatives East, and I deeply believe that bringing cannabis to a local community where several people of all legal ages use it. It is not something to fear or doubt for any reason. I personally fear for the people who have no access to local, safe, tested, and legal cannabis to get the medicine they absolutely need. Cannabis is used for so many different reasons. Cancer, migraines, eating disorders, all things people in your neighborhood and community struggle with. The cannabis industry comes to Bennett Valley with love. They come with help, and they come with safe information. And they come with the heart to make people's access easier and safer to the medicine they absolutely need. When it comes to our local community, opening Alternatives East will bring in necessary income to our community. It'll bring in jobs for our people and tax income for this desperately needed time. Alternatives is a discreet and tasteful shop. They do not use exterior signage indicating the selling of cannabis or anything that would jeopardize or alter the look of our community. Alternatives has a grade A security system that I personally highly believe will help improve the safety of our community in that area. And lastly, I think it would be highly unfair to deprive our local community and neighbors access to the medicine needed for severe chronic medical conditions. I do not believe it will change the character of our local neighborhood, and I hope you guys can envision that as well. Thank you for your time today.
Thank you.
Okay, next we have MHS Guest 3 account. So if you can please state your name for the record. And MHS Guest, you have the ability to unmute yourself at this time. Thank you.
Yes, this is Alan and Vicki Hardcastle. And we are residents of Bennett Valley for over 35 years, and we are joining our friends and neighbors in very strong opposition to this proposed retail dispensary located at 2300 Bethards Avenue. You've heard from Ms. Hutton, who stated a lot of the reasons why this should be opposed, and I would urge the commission to take a look at her written correspondence. I commend the commissioners for having visited this site, and it doesn't take long to see that this is a completely inappropriate and completely dissimilar use from every other tenant in that building. This is not a similar use. This is a business office that runs on an 8 to 5 Monday through Friday schedule, not a 12-hour a day, 7-day a week facility. Also, the Planning Commission needs to look seriously at why a conditional use permit is being sought in an area where there is plenty of retail space, as pointed out by the applicant. There are retail centers nearby. Those are appropriate places for a cannabis dispensary, not this office professional building. It doesn't take long to find those for lease signs throughout the city of Santa Rosa and in the nearby Bennett Valley area. This is a bad idea in a bad location. It's run by an operator with a questionable history other than a stellar history. And we urge the Planning Commission to deny the conditional use permit. We speak as concerned citizens of Bennett Valley. And by the way, nobody offered us a 1 penny joint to show up and give our comments. We thank you for your consideration.
Thank you, Mr. Hardcastle.
Next, we have Tamara Blass.
Hello.
Hey there.
Can you hear me?
Go ahead. Yes, go ahead and start. I'm ready.
I want to thank everyone for their time, and I'll try and be concise. I'm in the real estate field, and as a local agent, I actually really do understand the concerns of neighbors and local residents, as I too initially shared some of those concerns. No one wants to see their neighborhood go downhill, their safety compromised, or their home values go down. I've personally seen what bad decisions can do to a neighborhood. I recently visited my daughter in Portland, where a very well-meaning proposition to allow additional dwelling units has caused neighborhoods to have unbelievable parking problems and homelessness and all kinds of other stuff. But I've personally also seen what I've been following Alternative East and found that just the opposite has happened. What was a kind of blighted little street has now been transformed into a more reputable area. The building was done tastefully. I've seen the clientele just come in and go out. There's no loitering, there's no lingering. It seems like it's a legitimate and well-run business that's cleaned up the street and the surrounding businesses. My reservation regarding consumption has been addressed, which I was really strongly against that idea. But also the notion I want to dispel that customers will be somehow spilling into the nearby areas to linger and loiter and corrupt all passing children is just fear-mongering. I think most of those concerns have already been addressed. The cannabis is pre-packaged, pre-sealed, it's discrete location, and it really is not in a neighborhood. It's in a commercial area. A business with more foot traffic does bring more eyes and increase security, which makes it safer, as I've seen from the other location. And dispensaries, also, I have to say, should not be relegated to blighted areas where seniors don't have convenient and easy access. There's a lot of Oakmont residents who I know need a closer location with easier access. And it's funny how much people will open up to you if you get them talking. And I just remember a very, very embarrassed neighbor who I saw going out of the dispensary, and because there's so much misinformation and false equivalency regarding the use of it. But in general, I think that this is a well-run business. Oh, sorry, my time is running out. But I think there's overwhelming support from the community, and I also urge the commission to approve this measure. There's a lot of people with PTSD who use cannabis. All kinds of people using it for medicinal use. It is not recreational use only. And I think it's badly needed in our community. Thank you.
Next, we have Lauren M. If you can state your full name for the record.
Yes, it's Manus.
Go ahead and start when you're ready.
Yes, I'm here because I feel very strongly that alternatives should be allowed to open this new location. I've personally been in the healthcare field working for 5 years with often with oncology, cancer patients in particular. And I see patients from all backgrounds. It's really hard to see people in pain and suffering. And so I think that there needs to be more access to all sorts of healthcare, like alternative medicine, in all kinds of neighborhoods, that being the key for those in need. I think it's an advantage for patients to have closer access to the medicine they need. And also the last person alluded to the fact that Elderly people might need that kind of medicine, especially oncology type patients, and it's harder for them to get away, farther away to get their medicine. The suffering that's endured by these types of patients, I think, is minimized by the types of products that Alternatives offers, especially they do have an assortment of non-psychoactive CBD products that I'm aware of, which is used for pain in a very advantageous way, which is different than maybe a lot of the public would even know about. And I know the area, and with my background in healthcare and the things I see, I think it's very unreasonable for anyone to question that this new location should be approved, but have that in question. I think a lot of the people, a few that I've already heard so far who are in opposition, are prejudiced against the concept of marijuana in general. I think that they have no basis in fact stating that there are serious violence risk concerns. I think they have no studies on their side, and I agree with the last person that said it's basically just fear mongering with no basis in fact. I think that those who consider this medicine to be a necessity will be overjoyed, and I think they're going to be thrilled that there's a nice new dispensary near them in the community, and I don't see it being something that goes against the look of the community or like the last person was talking about. I don't think that it would drag down the community in any way. I think the opposite.
Thank you, Lauren. Next, we have Moira Jacobs.
Hello, thank you. I am asking the commissioners to not approve this application as it has multiple defects as communicated by Elizabeth Hutton and a number of other people that I totally support. I'm not sure if this group knows, if the commissioners know that you should have received a petition from hundreds of residents, actually residents in the area. I'm not sure if the people who spoke up about this are actually residents in Bennett Valley. It wasn't clear because they didn't state that. I'm a resident of Bennett Valley along with the other people who are opposed to this. We submitted a petition that many hundreds signed. It's a totally inappropriate location for this place. It has zero neighborhood compatibility. By the way, there's only one entrance and exit to this location. And by the way, we're talking about drugs. You say medicine, that's fine. Medicine is a drug. These are drugs, and nothing that has been recognized by the FDA that actually cures anything. But in any case, that one entrance and exit is over a sidewalk that children are walking every day on their bicycles every day, seniors walking across that sidewalk every day. And I'm not sure, even without consumption on site, if you can really guarantee that the people that are users of THC, which impairs your capability to use equipment or drive a car, yet our authorities still don't have a way to test for that with a DUI testing for alcohol, are allowed to go in and out of this driveway all day. And certainly the car trips are over the car trips that are reported here. So that is simply a farce. And this is a very, generally unhealthy drug, not approved at all by the FDA. And we're just jumping ahead here in Santa Rosa to try to promote the normalization of marijuana in front of our children's faces is, sorry, that's wrong. And this is wrong, and you really should place this elsewhere. You can deliver it to any of the seniors that need this stuff and want it. You can deliver it from wherever. So that's not really an issue. Thank you, and I totally oppose this.
Thank you. Next, we have Sharon Rogers. And Sharon, if you can unmute yourself, and then the timer will start when you begin speaking.
Hi, can you hear me?
Yes, we can. Thank you.
Thank you. I am calling, I'm a medical patient of alternatives, and I've gone there for quite some time. In fact, I don't go anywhere else. And I had fought cancer and with the help of alternatives, and I won. And I'm currently disabled, and I traveled from Rankin Valley to go to alternatives currently to help myself. And I run into, and I live in a senior community, and I've often ran into other seniors in the store that I would not have expected as well. But I just feel really compelled to say that her team they're professional, they're helpful, they're knowledgeable. I personally feel so comfortable leaving, coming in there. I just am very comfortable there. It's not a scary feeling whatsoever, and they're very helpful. So I would hope that that this alternatives would be able to go to the east side. That would help a lot of folks. Thank you.
Thank you, Sharon. Next, we have Diane Copes.
Hello, can you hear me?
Yes, loud and clear. Thank you.
Great. First off, I'd like to start by saying that I am a Bennett Valley resident. Nobody has offered me a joint for any price in order to make these comments. And in fact, I'm not a user, but I have a child who is of age, but struggles with severe anxiety and PTSD and is unable to go and make purchases on his own. So I have been using alternatives for a few years now, and I have to say I'm consistently impressed by the professionalism, the amount of information and knowledge that the staff is willing to share with me, and they will help me work to find exactly the right medication to best address what's going on with my son at any given point in time. I must say that I have never, in any of my visits to Alternative, ever seen anyone using in their parking lot, around the building, anything like that. People take they always offer you a bag for your products so that people do not see what you're carrying when you walk out of the store. I'm also impressed because they have accepted debit cards and credit cards, so it is not a cash business. They are also wonderful in offering what I call the wisdom discount instead of the age discount, which is helpful when you're doing this on an ongoing basis for someone with ongoing problems. In terms of it not fitting into the neighborhood, directly across the street, you've got CVS Drugs, restaurants, the 7-Eleven store, catty corner across the street, Safeway, MD Liquors, people who operate all hours. And so just the fact that they're in this building that typically shuts down at 5 o'clock, well, that eliminates some of the parking problems in the evening hours because there's no competition for those spaces. I also agree that because of their security and the fact that you've got increased traffic, it makes the neighborhood safer. The other thing I would say is that when you talk about bringing a troublesome substance into the neighborhood, there is an MD wine and liquor store in the Safeway shopping center. And I have, in fact, seen people drinking alcohol directly from hard liquor bottles, not right in front of the store because they would stop it, but right around there. And kids go in there to buy snacks. So it's not even an adults-only store. Alternatives has someone checking ID on everybody who comes in and out, making sure that you are of age and legally able to purchase the product. So I've just got to say, I wholeheartedly support this this Alternatives East expansion. Thank you.
you. Next, we have Bob. If you can please give your full name for the record.
Oh, hello, this is Ann. My name is Ann.
Oh, Ann.
Okay, I am a resident of Bennett Valley. The permit for 2300 Bethard should be denied for the following reasons. Number one, it is unsuitable for a densely populated residential area. It belongs in a retail commercial district. Kistler described it as a commercial corridor here on Bethards and Yuluba. And yes, there are businesses here, but I would not describe it as a commercial corridor. I would describe Santa Rosa Avenue as a commercial corridor. Number two, the applicant has proved to be untrustworthy over time. On July 18, 2010, in the Press Democrat, quoting from an article, it talks about the applicant's dispensary on Santa Rosa Avenue. Quote, one thing her shop outside Santa Rosa city limits doesn't have, though, is a legal license to operate from Sonoma County authorities. Quote, Kistler has been operating without a permit. They must cease operations immediately or begin applying for a costly permit that could make them legal. Moving ahead to the present time, regulations regarding permit hearing signage notification for the project, the applicant erected only one sign purposely placed back from the street off to the side last month in contempt of the zoning code. The applicant has clearly shown by her actions that she cannot be trusted by the city of Santa Rosa and the residents of Santa Rosa. And this pattern of behavior continues from 2010 to the present. Furthermore, she clearly did not have the well-being of her clients and residents of our area as a priority when her initial proposal included a smoking and vaping lounge on site, allowing customers to intake THC containing marijuana products on her property, then having them get into a motor vehicle and drive impaired in the neighborhood shows her abject disregard for the safety and well-being of the community, of my community. Although her proposal for the lounge was denied by the planning department, it showed her complete lack of care and concern for the neighborhood and surrounding areas, her lack of credibility and continued disregard for the rules and regulations of the city and county require you to deny this permit. Thank you.
Thank you. Next, we have Scott Candell.
Okay, can you hear me?
Yes.
Okay. Thank you for your time. I appreciate it. I wanted to take my 3 minutes, if I could, just to remind the Planning Commission that no matter where you put a dispensary, you're going to have people who are objecting to it. And they're going to be objecting on moral grounds that it's bad for kids and it's causes crime and all those things. We as a society have been debating this for a while. We ended up passing medical marijuana in 1996, 25 years ago, as a state agreeing that the benefits outweighed the negatives. In 2016, we passed it for recreational, and the state left it up to the cities to decide if and how they wanted this. Santa Rosa had robust debate and ended up deciding that it did want to allow dispensaries. Then it had robust debate about where those dispensaries should be placed and came up with their zoning ordinance, which specifically allowed the zoning where it would be allowed, specific distances that it had to be from schools and other sensitive uses. Alternatives appears to be complying with everything that's been required of it. When it was asked to change its layout, to change the doors to comply, it seems like it did. It seems like they've been doing everything right. Santa Rosa has made these requirements, and I see no reason why it should be denied. And thank you.
Thank you. last hand we currently have raised is Marissa. If you can please give your full name for the record.
Hello, can you hear me?
Yes, we can.
Hello, my name is Marissa Westling, and I just like to state that I approve this proposal for the new alternatives in Bennett Valley. I have been an active medical cannabis user for 9 years. My entire family has their medical cannabis card. Little information, my older sister has 4 diseases, including complex regional pain syndrome and degenerate disc with nodules along the spine, which left her paralyzed for almost 2 years. Also gastroparesis, which is a stomach and lower intestine shutdown, which when she has episodes leave her only nutrition source is a feeding tube. My mother has 3 different active cancers and 2 autoimmune diseases. My stepfather has multiple different spinal surgeries and shoulder surgeries that has left him crippled. I have chronic insomnia and PTSD. We have all benefited from cannabis throughout the past 10 years. We have all expanded our knowledge on cannabis and how it has truly benefited us. Certain products are only sold at certain locations, and I have found my home with Alternatives Health Collectives. I have made the commute for over 5 years and willing to wait up to an hour and a half for their product and excellent service. Expanding their store would honestly save myself and many others in the community to get our necessary medicine. Looking at the location on Yalupa and Bethards Drive is a very perfect location. Knowing that there is no one younger than 21 is allowed to enter the building and Alternatives does check for valid California IDs upon entry is a huge relief as a neighbor. Also, all the new security cameras inside and out of the building is a relief. Doing my research, the delivery drivers must have proof of a clean driving record upon hiring, the same as any other delivery service, which is also a very big relief knowing that there's safe drivers in our community. And finally, in my experience, I've seen more homeless and crime at the family restaurant I work at than at near any dispensaries. As for crime, any business someone believes has money is in danger. Recently, Thanksgiving 2020, I was attacked at gunpoint when leaving my work. Unfortunate people in hard times can make horrible mistakes, but there is no difference from a dispensary to a family restaurant. I would honestly benefit as a community member needing our medicine to get a more convenient location and product we can know to be tested and safe. Thank you, and I approve.
Thank you. And it looks like a few more hands have been raised. One moment. Next is listed as Maine. If you can please give us your full name for the record.
Hi, I'm Eric Simons. Can you hear me?
Yes, I can. Can you repeat your last name one more time?
Simons, yes. I live Creekside area, and I just think that there's been many great things said so far. I work with logistics in the entertainment business, and I must say that I look at the flow that they're talking about for increased traffic. And if they're expanding to 2 locations, I cannot see anything measurable within the community. Furthermore, they're talking about having no signs available as well. So I think this will be an invisible business to the community, and it's a service that's provided throughout Santa Rosa. My biggest concern is that we're looking at unequal application of where a dispensary can be. There's other places in Santa Rosa that have similar situations. The zoning for the area is commercial. So therefore, it's unequal application of having a dispensary in Santa Rosa to say it can't be here in Yalupa, Bennett Valley. Not only do I support them being there, I think that they would be a great contributor to the community, but the negative harms, things that are being said against Karen are horrible because they do not reflect the business. My sister, my wife, people that I know that depend on CBD cannot get it unless they go to a dispensary for oral application. And that's for pain. They do not partake of THC or get high or anything like that. And I go to Alternatives because for my wife, I can actually get the proper CBD that is helping her with her migraines And I think it's important to realize that the complexion of the business is multifaceted. And also too, I think that there's been so much thrown around against this business that's really, to be honest with you, not fair. Having witnessed that I think that we just should look at the fact it's another business, it's commercially zoned, and they're doing nothing, absolutely nothing that's going to be different than a similar location in other parts of Santa Rosa. So is Bennett Valley, ULIPA going to discriminate against things that are accepted in other parts of Santa Rosa? I hope not. Thank you.
Thank you. Next, we have listed as Lakeview Drive. If you can please give your name for the record.
Hi there. My name is Alex Ducey, and I am a resident of Bennett Valley. And I've been here for probably 25 years now. I'm just weighing in. I think that I don't have an issue with medical marijuana or its uses. But living here, I was very surprised to hear that this area is an intense commerce corridor. I have to disagree with that. And I would like to try to compare that to the commerce corridor in Roseland off Sebastopol Road, where the other alternatives place is. I think that's, it looks like it's not at all the same. I do have an issue with the fact that there is a lot of foot traffic going back and forth around that area with kids from the bus when schools finally get back to normal. And I don't think it's a really good fit for our community here. And I think there's plenty of other retail space, maybe closer to Oakmont, where they could open up shop. So I would put my vote in to oppose this. Thank you very much.
Thank you. One moment, Shirley. Got a couple more hands. If Maureen is next, if you can please state your last name for the record.
Grafeld. Hi. I'm opposing this, but you know, it's been really hard listening to a lot of the people weighing in that are basically saying that anyone that's opposed to it is opposed to cannabis, and that's really not the case. I think the majority of people that live in Bennett Valley are opposed to this based on the location. I think the city has a responsibility about where they're going to put these dispensaries. And to me, this is office space. I found it intriguing that the person who owns the property said so many things that were untrue. I have walked through that facility and I've talked to just about every single tenant that she has, and they're all leaving, including Mike Robertson, who was part of the last presentation that you had about the tree and the house lines. They're all leaving. They've been there. Most of those people have been there for 20 plus years, and they really want nothing to do with this, but they also want nothing to do with this landlord. This landlord has a history that goes, I mean, she has lawsuits and unpaid people. The people that have worked on that building since she's owned it have gone through and told so many of the residents in there that she's not paying the bills, that she hires unlicensed people and then they have no recourse, she doesn't pay them. I mean, I'm listening to stories that you have no idea the trail this lady leaves behind as a landlord. And if you would just look at her property on the west side, it's an embarrassment. But as far as, you know, cannabis, I have no problem with it. And put it somewhere else in Bennett Valley, but try to put it in somewhere where it's more appropriate. This building is 10 feet from homes, 10 feet. There are families living in those homes right behind there. It is surrounded by apartments and homes. This is an office space. There's no retail on that side of the street at all. It's quite a ways away. But I think the city has a responsibility to put these dispensaries in places that are more trafficked, where there's more exposures to people that are coming in and out and not sort of hidden away where, you know, a lot of other issues can come up. But this is definitely a residential area and it's office space. It's not retail. And I just think you have a responsibility to be careful what could potentially happen in this area as far as she has had robberies in her other locations, and that would be my biggest concern, along with the students. I was a teacher here for 30 years, and I know all the children congregate on that corner. They get picked up by buses. So I oppose this, but not because it's medical marijuana or cannabis or whatever. That's not my issue. It's the wrong location. Thank you.
Thank you. We have another hand raised, Teresa Brunner.
Hi. Thank you very much. I am opposed to this application, and I'd like to thank everyone who has spoken here opposing, and also the well-spoken Elizabeth Hutton, who brought up so many points for me. I believe approving this application would open the door for other unsavory retailers. And while Tamara Blast believes our area is not a neighborhood, I would suggest to expand the commercial map so she can see the dense neighborhoods surrounding the location. I'm also concerned about the private consultation room and what exactly would take place in there. That's all I have to say. Thank you so much.
Thank you. And Chair Weeks, with that, we have no other hands raised. Chair Weeks, you are muted at this time. We can't hear you.
Sorry. I just saw another hand raised.
Oh, you're correct. We have one more. Thank you, Chair Weeks. Next, we have Spencer. If you can please state your name for the record. And Spencer, if you have the ability to unmute yourself, so if you can please do so. Thank you.
How about now?
We can hear you loud and clear.
All right, sorry about that. My name is Spencer Oldfield, and I live in Bennett Valley, and I support Alternatives East. It's almost comical to think that having a dispensary like Alternatives in our neighborhood will do anything but increase joy. People leave Alternatives with a good feeling, knowing they got a good deal and great service. People of all races, genders, and ages, we all meet up together with a common interest and goal. It's a small family that is the epitome of a mom and pop shop. It's unlike a lot of other dispensaries in Sonoma County. I feel good spending my money there, knowing I'm supporting the community. Please allow them to open a location in our loving neighborhood. Thank you so much.
Thank you. So it doesn't look like there are any other hands raised. Mr. Maloney, is that correct?
Correct. There are no other hands raised at this time.
Okay. So with that, I will go ahead and close the public hearing and bring it back to the commission. Are there any questions that the commission has for staff or the applicant? Vice Chair Peterson?
Yes, I've got a couple for staff. I'll start with kind of the easy ones. What's the standard for the odor portion of cannabis retail?
Yeah, I can answer that. The standard is that it cannot, it can't go outside of the walls. So the application here would be that if they are in a building such as this with other tenants in common area, it can't leave their suite.
Okay, great.
It cannot leak outside of their suite.
And in terms of sort of, enforcement, so conditional use permit has conditions of use. What's sort of the enforcement if those conditions aren't met?
Sure. So say you have complaints about odor. There's a mechanism. The first one that comes to mind is the code enforcement division of the city. say a tenant of the space or a neighbor walking by smells the odor, they would file a complaint with code enforcement. They're obligated to check on that complaint, and then what they find determines whether a case is open and pursued further from that point, or if they find no violation.
Okay, great. And in terms of the sort of location, the zoning requirements of the of cannabis retail sales, that's tied to the lot. Is that correct?
Well, the use permit would run with the land. Is that what you're asking?
So I mean, the lot is going to be zoned something, and there's some other requirements about setbacks from schools and stuff. But it's not sort of the area in general. It's the lot itself that that would allow. It needs to be general industrial or light industrial, whatever.
That is correct. Yes.
Okay. I may have some more, but let me turn it over to the rest of the commission so I don't monopolize this time.
Hey, are there any other questions? Commissioner Carter?
Yeah, could we briefly be shown where the delivery operations will function out of? Generally the route for bringing materials to the operation and delivering product from the operation.
Yes. Give me 1 second and I will share my screen again.
And sort of as a follow-on to Vice Chair Peterson's question, a use permit, when approved, is approved as submitted. So in order to change any of the operations, would it be necessary to modify the use permit? Should it be approved?
Yes. So say they wanted to expand the hours of operation at a later point in time, that would require a return to the Planning Commission for review and approval, or review and yes, Planning Commission's approval.
I think that's all I have for now.
This is the floor plan as you requested, the one that was received today, which is still the same as what was previously provided, so this comes in here. This is where the vendor distribution and the delivery services would come in and out of. So I'll go right here. So as you see, parking over here, entry here into this common corridor, and entry in the back. This is the only entrance for this site as proposed, with the door facing Bethards Drive for members of the public, customers entering the site. I'm sorry, you're muted, Commissioner Carter.
And do we know if any of those spaces on the south side of the building are reserved for the delivery and operations of the facility?
That's a good question. Give me 1 second, 1 minute, and I'll verify that for you.
Thank you.
If you have other questions or want to move on, and I'll look it up just for verification while we move forward.
Thank you. Commissioner Duggan, I think, did you have a question?
Yeah, I had a couple of questions that were tied to comments from the public.
Okay.
And the two for staff are to verify that he did indeed get a petition that one of the commenters brought up. And then also the private office for consultation. Somebody asked what would happen within that room, and I guess that's more for the applicant to respond to. And then there was a question regarding the traffic study and why did the numbers change? And just an explanation of that.
Okay. So
I can jump in while Adam, I think he's researching the previous question.
Okay.
So I think two of those might be most appropriate for the applicant and their team with regard to the traffic study, as well as what activities will happen in the consultation room. And then I think I defer to Adam, so we might put this in the parking lot as well about the petition, and we'll come back to you on that one.
Okay. So can we promote the applicant to a participant to answer those questions?
Good evening, Madam Chair, Commissioners. This is Cameron Nye, Associate Engineer with W-Trans, and we prepared the trip generation estimate for the subject project. And I can answer the question about why the trip numbers have changed. When this project was initiated about 1.5 years ago, the original estimate was based on national standard rates that were considered the best available data at the time the study was initiated. Since that time, W-Trans has collected local data here in the city of Santa Rosa, Sonoma County, city of Napa as well, and we have developed new rates that are specific to the dispensaries that we see in our communities around here. So that's why the trip numbers changed as the report moved along into the final version.
Thank you. And then the other question, excuse me, for the applicant was the purpose of the private consultation office. So if we could promote the applicant to a participant.
Can the applicant please raise their hand? We have quite a few members in the attendees.
Oh, sorry.
Thank you.
Great. Thank you for the opportunity to respond. The private consultation office is not for dispensing cannabis or for doing anything other than if someone has a private consideration that is personal to their own lives, if they want to speak with one of our cannabis technicians or one of our bud tenders just about concerns that they have, it's just a private space. It's just to allow for some private conversation. Right now at the dispensary, for example, a parent could walk in and talk about what some side effects may be to a certain kind of or ratio of CBD to THC, and it's just a place to talk with people. But in addition to that, we consider one of our most important goals is that to educate the community. So, for example, we had Connor O'Neill come in and talk to our growers when he's from the Water Quality Control Board. And he came in and he talked with, it must have been 30 growers when the new regulations were being proposed and were being debated. So we had an education center, a consultation room, as it were, to allow people to get together and talk about application of these regulations and speak to government officials about how they might apply. We see some of these rooms to provide education centers for community groups that may not have otherwise a safe place to meet, to talk about issues that are concerning to them, like the new cultivation ordinance that's coming up. But really, it's just it's a room for people to talk about issues that concern them. But there's no cannabis is sold in the room, and there isn't consumption there, and it really is just extra space to interface with the community in a way that might be helpful to them.
Thank you. Commissioner Duggan, did that answer your questions? Other than the petition, we're still waiting on an answer about the petition, correct?
Yes, thank you.
Okay. Commissioner Holton?
Yes, I just had one question in regard to smell mitigation. I was wondering how you were going to achieve that. Would it be through activated charcoal filters in your HVAC system, or do you have a more kind of aggressive approach to mitigating the smell? My concern is just due to the close proximity of the neighborhood.
And Chair Weeks, I think that question would be best for the applicant. Yeah.
Sorry. And the applicant actually had brought a specialist, and that's probably more for the specialist.
Exactly. Thank you.
And I was also wondering about parts per million as well, like what would be the acceptable range. So
right. If James York is not here, I can respond that the unit generates 3,500 CFMs. And it's a combination of coir and charcoal.
Okay.
It's considered state of the art for commercial settings. It has massive turnover. Yeah.
What would do you have developed PM schedules currently as far as because I know, especially with coir and activated charcoal, you'll get, with residues like that, can actually leave residues on the material and over time. So I just wanted to make sure you guys have planning for adequate PM schedule.
We do, and we're not cultivating. If by PM you mean the
preventative maintenance. No, preventative maintenance. Sorry, we all have so many acronyms in our industry.
Right. We're hoping the clones that come in are clean of all of that.
Yeah. No powder mold. Yeah.
No, thank you. No, we have the unit manufacturer requires a 6-month turnaround of the filtration, and we have a schedule that will definitely invoke for that. But we have multiple redundant systems, including charcoal filters in each room. And
great.
I know, and I know that James York, who apparently had to leave.
I'm on the call actually.
Oh, I'm so sorry. Thank you. We'll talk about the redundant systems that we have. Please carry on.
Oh yeah, I just wanted to add that it's a carbon system, and we have seen them work with success at other cannabis facilities, both, I guess all retail, shipping and handling, as well as actually grow ops using the same technology. And in terms of preventative maintenance, one of the things that we usually recommend is going outside and smelling for it, because if you can't smell it outside, other people can't smell it outside. And that would be part of a odor mitigation plan, certainly.
But just due to the close proximity of the neighborhood, you don't want your employees to have to go out every, hour and a half or every day and be like, hey,
right. Yeah. So
do you have any idea as far as what is the local or the accepted rate of parts per million for smell mitigation? I mean, is there I'm not sure if there's actually currently a statute in place. So
there's no statute generally for parts per million on any of these things, especially because the organic compounds involved in odor are sometimes different and numerous.
Yeah.
In the case of cannabis, it tends to be the terpenes, which I believe generate a majority of the odor, and they can be smelled in volumes as low as 1 ppm. But we do also see that the volumes going through the carbon systems are generally low to begin with, and then the carbon systems can control as high as 99%.
Okay, great.
And like Karen said there, they tend to have a lifespan of about 6 months. And so, right, you're not going to go outside and test for smell every hour, especially because your nose is not going to be very sensitive to cannabis odor if you were just working inside the facility.
Exactly.
So what we often say is that part of the odor mitigation plan would be, in the morning when you arrive at the facility, you go to the carbon filters, you stand there, you smell, because it's blowing air out of the facility into the parking lot. And so you would then stand there, smell, see if there's anything, and then you mark down nothing happen today. And like Karen said, you replace the filters as described by the manufacturer or the first time you detect that odor. So that's generally how it's done. And the regulations you were saying, the statutes are nuisance statutes, so it tends to be based on complaints more than any scientific quantitative value.
Well, and with that being said, just due to the close proximity to a neighborhood, it might be in your best interest to make sure that you're just strictly adhering to those suggested preventative maintenance schedules.
Yeah, I would say, as allowed and per, I guess, whichever one comes first, right? So do what the manufacturer says, but be vigilant as well.
Yeah, you are really in close proximity to, residential, so.
Thank you, Mr. York. So we're still waiting on question on dedicated parking for delivery and the petition. Mr. Ross?
So to answer about the parking delivery, I was double checking to make sure I didn't miss it. I had not seen that there was a dedicated delivery parking space in the application packet, nor is it in the project description. So I would say no, unless the applicant has said otherwise. As far as the petition in opposition from the application before you, there was a lot submitted, and if I did receive it, there were hard copies that were scanned in, provided to you. So if I received it, it should be in there. I am going through the application packet to find that to verify as well for you right now.
Thank you. Any other questions by the commission? Vice Chair Peterson?
So I think these are for staff. One was a public comment that said they thought the noticing was inadequate. Can you talk about the sign that goes up when there's a conditional use permit and sort of whether the standards were met?
Yes. So for the February 25th public hearing, for which this was originally scheduled and continued from, the deficiency was missing one on-site sign. So under the zoning code section 20-66, it defines what the notices should have on them, where they should be located, and the like. When I did a site visit after receiving emails saying there was a deficiency, I did notice immediately that there was one missing. The other sign, while it wasn't right in front of the entrance of the building, it was still on the front side of the entrance in the landscaping. So as to my understanding, the deficiency was only in that it was missing one sign on the Yalupa Avenue frontage. But overall, the required noticing is a postcard mailing that goes out about 2 weeks before to allow for 10 days prior to the public hearing to residences, owners and occupants of properties within a 600-foot buffer of the parcel lines of the given site of whatever the public hearing item is, as well as a notice in the Press Democrat providing more information. And then the on-site signage. In addition to that, most things are posted on the city website for those who want to be notified for all city projects being noticed as they come up, whether they're a notice of application or a notice of public hearing. So it would have also been in that location as well.
Thank you.
I have a question, and this is just to verify for some of the public members that the application is referred out to various departments, including the police department. Is that correct?
That is correct.
Okay, thank you. So let's see. Any other questions? Commissioner Duggan?
Yeah, this is just another clarification about one of the commenters, when the public made a comment kind of indicating like his belief that this application needs a conditional use permit because of its location, its proposed location. Could you just describe how any cannabis delivery, any cannabis dispensary requires a conditional use permit?
Yes, absolutely. You essentially said that, is that any cannabis dispensary is required by approval of a conditional use permit. Some of those areas that would allow it by conditional use permit under zoning would be commercial office, which is this one, commercial, general commercial, light industrial as well, I believe, and some other, mostly commercial. There is, if it was a residentially zoned property, you could not submit a conditional use permit. You would have to go through, I mean, it would have to be approved, but a rezoning. So, and that's highly unlikely that that would happen. It would, I shouldn't say it would never happen, but they would, if it was residentially zoned, they would have to rezone it to commercial property as well.
Yeah, I think just to kind of summarize what Adam was saying, it's a conditionally permitted use in this zoning district. And so therefore, this is the proper mechanism. And just to touch back on the noticing question, there was a deficiency that has been remedied, and there are at this point no deficiencies in the zoning code. The zoning code does allow for a noticing deficiency to occur, and we can still go forward with hearings. We've done that before. The commission's familiar with that. That is not the case. There are no deficiencies with the noticing on this project.
Thank you. If there are no further questions, if somebody would like to make a motion, and we do need to have some language in the resolution, I believe.
Yes, if you were to adopt the floor plan submitted today, the resolution would be changed to state that. If you give me just a minute, I'll let you know exactly where it would need to be located in that resolution.
Thank you.
Adam, I can probably jump in on this. When the motion maker makes the motion, it can read into the record. If it's, we'll just assume for a minute, if it's a recommendation for approval, it would be recommendation for approval, read in the typical introductory statement that you see, and then just say, including the amended site plan received March 25th, 2021.
Okay, thank you. So would somebody like to make a motion? Commissioner Duggan?
I'll move a resolution of the Planning Commission of the City of Santa Rosa making findings and determinations and approving a conditional use permit for Alternatives East to operate a cannabis retail facility with delivery service within a 2,449 square foot tenant space located at 2300 Bethards Drive, Suite A, Assessor's Parcel Number 147-061-015, file number PRJ 19-047, including the amended site plan received March 25th, 2021, and waive further reading.
Thank you. Is there a second? Commissioner Holton? Okay.
Yes, I'll second.
Okay, thank you. So that was moved by Commissioner Duggan, seconded by Commissioner Holton, and comments by the commission. We'll start with Commissioner Okrepke.
All right, thank you. So a few comments on this. The first thing is that there's been a lot of claims made by some of the public commenters about this kind of business and what comes with it that just aren't founded in the evidence that we've seen that we get presented. there's no evidence that a dispensary increases crime. There is random crime, but there's no more crime for dispensary that we've seen than, say, a random 7-Eleven, or, I mean, from my recollection, there's been more bank robberies in Sonoma County than dispensary robberies or cannabis business robberies in recent memory. Also, someone made the comment that delivery is just a cover for distribution. No, by code and ordinance, delivery and distribution are two extremely different things with extremely different regulations. So that's not the case. If they do distribute out of there, that would violate the conditional use permit, and there would be repercussions for that. As far as, you know, the kids walking by and it doesn't fit the neighborhood and this and that, I grew up in Bennett Valley. I spent the first 21 years of my life in that area. I went to Strawberry School. I know that area very well. There, by my count, just from the presentations we saw, are about 10 or 11 businesses that serve alcohol in there. And the assertion that somebody who would have on-site consumption exposes some sort of character flaw by wanting that within their business, even though that's not proposed, is also inaccurate. We do have consumption businesses approved in this city. We also have bars and restaurants that let people consume alcohol, and it is incumbent upon the business and the consumer to regulate themselves as to whether they get behind the wheel or not. As far as, you know, this is too close to a neighborhood, this is too close to where people live, I suggest you look up other areas that have cannabis businesses, as they have over on the west side and in the northwest and southwest, businesses that share fence lines with homes. And we have heard this, discussed this, and it is incumbent upon the business to follow code and the odor mitigation plans and safety and all that. So saying all of those things, I want to make it clear that we, you know, I find myself saying this almost every 2 weeks or whenever we have a meeting. We're not policymakers. You say we're just checking boxes, and we do have leeway, we do have latitude in certain things in making these findings, but if you want to call making findings and making sure that each applicant reaches this certain threshold, checking boxes, feel free to do so. I disagree, and I'm sure the other commissioners would disagree as well. But we can't go off of this isn't good for the neighborhood if there's no factual evidence that it affects a nearby business or that it does increase crime. And if those things do in fact happen, that usually gets stopped in planning. So all those things being said, I can make the required findings to support the application. I will say that the one thing that does concern me very much is the screenshot that was sent to us, basically offering pre-roll joints for a discount for public comment. As someone who sits on this commission, I can say that when I listen to somebody, either when it was in person or now, or we get some sort of email, I want to believe that those people are speaking from the heart and speaking for something they truly believe that is either good or not good for their community, and not being essentially bribed to speak on the behalf of a business with disingenuous intentions. That, as I said, is something that would be a policy issue and my preference, and I can't use that in making my decision. So therefore, as I said, I can make the required findings and will be in support of the application.
Thank you. Commissioner Carter.
Well, I thought Commissioner Okrepke's summary was pretty darn good. As he mentioned, we have seen similar applications. We have heard similar arguments, and we have not been presented evidence to support some of those arguments against cannabis use. And it's clearly the intention of the city in adopting a cannabis ordinance to have it widely distributed and available throughout all new neighborhoods in Santa Rosa. And we've heard over and over again that the eastern sides of town are lacking in dispensaries. And for those reasons, I will be supporting the application.
Thank you. Commissioner Duggan?
Yeah, I also second Commissioner Carter's comments about Commissioner Okrepke's comments. They were right on the ball. My only reservations that I did have, I just, to the public who don't usually attend our meetings or speak at these things, and people who spoke passionately against this dispensary, our purview is land use, and we have to decide whether something meets the requirements of the zoning code and the general plan. And I can make all the required findings. My two reservations were the direct entrance off of one of the street frontages. I was the commenter who asked about that, and also whether odors could transmit throughout the building. And I'm satisfied with the answer that they won't or they shouldn't, and if they do, that they can be rectified and things will be changed, and that won't happen on a regular basis. So I'm in support of the project.
Thank you. Commissioner Holton?
I really don't think there's much more I could add on to what Commissioner Okrepke said. I mean, really, he hit the nail on the head. And thanks for taking the lead. I appreciate that because you really just summed up everything I wanted to say. I'll just say I'm also in support of this project. And if it were me, I'd be buying stock in Baskin Robbins. And that's all I have to say. Thank you.
Vice Chair Peterson?
Sure. So my fellow commissioners have very ably, discussed the issue, and I share their feelings on this. I do want to take a moment to acknowledge that, this is an ordinance that's been in effect for a few years, but it still is change. And I think change, especially for something that is illegal at the federal level, is challenging. So while I understand where, the public is coming from, I think we also have to acknowledge the reality that, keeping cannabis marginalized or illegal wasn't working. And the city deliberately made a decision after a lot of debate, a lot of input from stakeholders, including the police department, about how to construct the cannabis ordinance. And just to emphasize the point that's already been made, the cannabis ordinance was designed to distribute retail cannabis facilities throughout the city. And it was done deliberately. You avoid inducing traffic, you avoid, certain areas having to bear the burden of kind of a red light district for cannabis, and the associated kind of stuff with that. So the idea that, Bennett Valley or this location isn't appropriate for cannabis, that's not what the cannabis ordinance says. The cannabis ordinance says if you meet these criteria, it's the right zoning, it's this far from schools, it's, this far from other cannabis dispensaries, it's got, minimal signage, it's got odor control, all that sort of stuff. You can put it there. And so this meets the requirements of the ordinance. And, I think it's appropriate based on the ordinance itself. And just as an aside, my fellow commissioners have hit on this already, but a member of the public, I think, made a good point, is Sonoma County is swimming in alcohol, and this location has multiple bars, liquor stores. Kids can see the liquor for sale in the Safeway across the street. It's really hard for me in 2021 to draw a meaningful distinction between the dangers of alcohol, the crime associated with alcohol, the risk it poses to children, to driving drunk, and cannabis. And so I think, again, the ordinance was well debated. It's decided to treat it, basically the same as alcohol with even more restrictions. And that includes things like, increased security and things like that. So with that in mind, I can make all the required findings necessary for this conditional use permit.
Thank you. And I also can make all the required findings. And as has been previously stated by my fellow commissioners, we've been seeing these applications for a few years now. And this is a good application. And I also like the fact that it is in a different part of town than we have seen a number of the dispensaries. And as was stated also, that was the intent of the council when they crafted the ordinance, was to disperse it throughout the community. I am in support of this. So with that, it was moved by Commissioner Duggan, seconded by Commissioner Holton. Mr. Maloney, do you want to call roll or take the vote?
Yes, thank you, Chair Weeks. Commissioner Carter?
Aye.
Commissioner Duggan?
Aye.
Commissioner Holton?
Aye.
Commissioner Kelly is absent. Moving to Commissioner O'Krepke.
Aye.
Vice Chair Peterson?
Aye.
And Chair Weeks.
Aye. So that concludes our business today. We are adjourned to the next scheduled meeting of the Planning Commission, which I believe is, can you tell me the date?
April 8th.
April 8th, okay.
April 8th, there you go.
Thank you. So with that, unless anybody has anything else, we'll adjourn for the evening.
Thank you, everybody.
Bye.